All right, ladies and gentlemen, it's about 9 o'clock. I'm going to go ahead and call the dockets. I'll begin with the Frio County docket. In the matter of the marriage of Travis and Ashley Bradford. Anyone? All right, there's a 972 telephone number that I'm asking to, I'll ask who that is.
Hi, good morning, Judge. This is Michael Garza, attorney with Scott & Associates. I apologize, I don't have video access this morning, so dialing in by phone.
Okay, I'll rename you. Thank you.
Thank you.
All right, then we've had an Ashley. Vasquez is trying to connect to audio. See if she makes it. Probably don't have two Ashleys. There she is. All right, Ms. Vasquez, are you Ashley Bradford also? All right. There's someone on called Ashley Vasquez. Are you here for the Bradford divorce? Okay, I'll recall. In the matter of the marriage of Gerardo and Olivia Trevino.
I'm here, Your Honor.
All right, is Olivia Trevino?
I don't believe so.
All right, and are you ready to proceed with your divorce, sir?
Yes, Your Honor.
All right, I mean, first ask you to remove your hat. And do you have your proposed divorce decree?
Yes, Your Honor.
Okay, do I have a copy of it?
Posted it on e-file last night, Your Honor.
Your Honor, it's been forwarded to the court coordinator.
Okay, I'll check in just a moment on that. Sandy Leal versus Ryan Garcia.
Your Honor, Locke Henry present for plaintiff Sandy Leal.
And this is a TRO where you were trying to preserve evidence from an automobile collision?
That's correct, Your Honor. We were hoping to have the temporary injunction hearing today. However, we've been unable to serve Ryan Garcia, even though we've made several attempts. So I submitted a motion to extend the TRO yesterday evening, along with a proposed order, which would extend the TRO, setting the TI hearing on December 16th, which is 14 days from today.
Okay, I will assume that's in my queue. You can either send it to me in chat or I'll log into my judge's queue.
If you prefer, Your Honor, I'm happy to send it to you via chat.
That way we know it made it.
It is in your queue as well, Your Honor. It was forwarded
well,
this morning.
All right, well, hold on well, I don't know what the coordinator though is. Who is speaking?
This is Locke Henry speaking.
No, I mean,
Oh, sorry.
who told me it was in the queue?
It's Gloria, Your Honor, from the district clerk's office.
See, I'm not sure though if the coordinator's office has sent it to me.
Okay.
When y'all forwarded it, goes to them, not to me, so. Let's see if e-file works this morning. Well, I'll return to that. Let's see if it's going to work or not.
I'll send it in the meantime via chat, Your Honor.
Thank you. All right, Frio County add-ons. Matter of the marriage of Crane. Mr. Ramirez?
Yes, sir. My client and I are present. This is a proof of divorce. I've e-filed the agreed divorce decree that has been signed off by both parties. We simply need 2-3 minutes of the court's time.
All right, I'll mark you number 1.
Thank you.
All right, Atascosa County, San Miguel versus Peeler. What are your time estimates for today?
1.5 hours, Your Honor, from the Peelers.
Your Honor, Mark Guthrie, Kiewit Mining Group, probably another 30 minutes or so total.
All right,
2 hours sounds about right, Your Honor.
all right, 3 hours it is.
2, I'm sorry, 2 hours.
Well, now it's 2, but I'll say 3. I think we'll get to you fairly quickly. Do I have a Dropbox or some sort of link for all of your pleadings for this morning?
Yes, Your Honor, we sent it to Ms. Riley yesterday, but I can put the link in chat if you'd like.
Please, I've been at the house the last couple of days because I had one of our sons was sent home with the COVID symptoms, and I was sure he was not positive, but we got the call this morning that all of our tests were negative. So in rushing around, I didn't get a chance to look at my emails this morning. Okay, Wilson, in the interest of Presley and Brown Ivy. Has that been dropped, I take it? Okay, I'll recall.
That was dropped, Your Honor. Sorry, I got logged in late.
Okay. JH Portfolio versus Brenda Peters.
Good morning, Your Honor. This is Michael Garza on behalf of JH.
Good morning. This is Josh Pico on behalf of Brenda Peters.
Okay, and it says debt collection 1 hour. Is this a trial on the merits? What's going on?
No, Your Honor, the parties have resolved the case. We've e-filed an agreed judgment on December 1st. Contacted the court this morning. I don't believe it's made its way to the queue. So just prior to this conversation, I emailed a copy of the agreed judgment over to the court and copied Mr. Pico on it as well.
And Your Honor, that is in your queue.
All right, I'll sign that. I'll put final judgment here, and if that's all you have, you're excused.
Thank you, Your Honor.
Thank you, Your Honor.
Yes. Okay. Wendy Sue Wagner et al. Versus Travis and Brenda Mendiola.
Travis Mendiola present, Your Honor.
Okay, who else is here?
Eloy Ita, counsel for plaintiffs present, Your Honor.
All right, so what do we have to hear this morning?
I believe this pro se litigant, there's I think pending with the court, a motion to withdraw filed by Mr. Oscar Cnty. This case is set for a merits hearing next week on the 9th. And I believe Mr. Mendiola is trying to ask for additional discovery time. That's what this is for right now.
All right, Mr. Mendiola?
Yes, Your Honor, I'm here.
Okay, so it says you have a motion for continuance?
Yes, sir. The attorney, Oscar Cnty, he was in and out of that organ transplant hospital, and I guess he has cancer, and he hasn't been able to send me any files because his scanner broke, and he just pretty much gave up, it sounds like. So I need to move on and try to find some counsel or prepare to, I don't know, maybe go in front of a jury and state my case to them if possible.
All right, sir, I'm going to ask you and Mr. Ita to confer in a breakout room in a few moments, and I'll come back and hear this if you're not able to come to an agreement. I can tell you that, having an attorney go down like that is a unusual circumstance, but it wouldn't be a reason to put this off for a significant period of time. So I'll let y'all confer in just a moment. In fact, I will go ahead and let's see, is Riley on or Norma's on?
It's Norma, Your Honor.
Okay, I will make you the host.
Okay.
So you can assign people to breakout rooms. If you would make me the co-host, I'd appreciate it.
Yes, sir.
Matter of marriage of Lorma.
Yes, Your Honor. Ashley Duffy, present for petitioner.
Good morning, Your Honor. Boyd Bauer for respondent. Your Honor, this case was set for temporary orders. It's settled. I believe Mrs. Duffy may have e-filed that agreed temporary order this morning. If not, it will be shortly. And so no hearing necessary. And Your Honor, the only other housekeeping matter is I had filed a motion to substitute There's an agreed order that should be, it was also e-filed, that should be available for your signature. And we'll just need that to be signed.
Okay, I will mark you as the current attorney and I'll get those signed.
Thank
Your
you,
Honor.
Honor.
And your excuse, thank you.
Thank you. Have a good day.
Waiting on my Acrobat machine program to come back to life. Okay, well, the Wilson County criminal case was rescheduled for Monday. All right, Mr. Henry, here is your motion. The judge's queue.
Excuse me, this is Travis Mendiola. Are we supposed to go into a side meeting room?
Yes, Norma will assign you to that in just a moment.
Okay, thank you, Your Honor.
Okay, I've sent that TRO directly to the clerk's office. So let's see if this is working. Yes. All right, in the matter of the marriage of Karen Crane and David Howard. Mr. Maris, you want to swear in I'll swear in your client?
Yes, sir, please.
All right.
And Mr. Howard may be here. He indicated by email I got this morning, but he sent it late last night that he was going to try to attend. He has signed off on the decree. I told him I was going to submit only that. If he's present, I'd like him sworn in as well. I don't know if he is or not.
All right, is Mr. Howard here? Is Ms. Crane here? Here's David Howard, okay. All right, somebody invited me to a breakout room. Norma, that's, if you just make me the co-host.
I see that as well. I don't know what that is.
Yeah, y'all can disregard it.
All right, again, Mr. Ramirez, is your client on?
Yes. Karen, you have to unmute that button. You have to hit the little microphone. Hit the little line through it. Unmute yourself.
All right, is that the lady with the vertical picture?
That's the lady that says Karen Crane in front of her. Can I walk down? She's downstairs in my conference room, Judge. Can I go and mute her?
Yes.
Let me go and mute her.
She's up in the top left. I'm sorry.
I'll get her.
Judge, you also have one more Wilson County case on page 2.
Oh, did I miss something? I saw Mr. Cluck here. Okay.
I think I got it.
All right, I only have one page on my docket. What's the other one? Was that Menard?
Judge, can you hear Miss Crane and I?
Yes.
Okay, good. She's unmuted. And Mr. Howard, I think that's your phone or connection making that really weird noise.
Mr. Howard, do you have some other electronic device going near you?
No, sir.
Okay. All right. And I'm asking you to start your video, Mr. Howard.
Judge, I can proceed with Miss Crane and
okay,
if that's okay with you.
Will the parties waive a record so Ms. Cavazos doesn't have to try and take this down?
Yes, Your Honor.
All right. Okay, Mr. Howard, Ms. Crane, would you raise your right hands? Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay,
Yes, sir.
go ahead, sir.
Okay, Karen, I'll start with you. Can you please state your name?
Karen Crane.
And Karen, are you the same Karen Crane that hired me to instigate and file a divorce action that is pending in this court in Frio County against your husband, David Howard?
Yes, sir.
And are you asking the court today to grant the divorce that you and David have worked through and resolved?
Yes, sir.
Now, prior to filing this lawsuit, had you been residing in Frio County for at least 90 days?
Yes, sir.
And had you been residing in the state of Texas for at least 6 months before this divorce was filed?
Yes, sir.
And has the marriage become insupportable because of discord or conflict of personalities that has destroyed the legitimate ends of the marriage relationship?
Yes, sir.
Is there any reasonable expectation that you and David will reconcile?
No.
Did you all have any children as part of this marriage?
No.
How long were you guys married?
6.5 years.
Okay. And have you and David worked together with me kind of helping you all along to resolve the issues of assets and debts and how they're going to be divided in this estate?
Yes, sir.
And have those details been agreed upon by you and David?
Yes.
And has it been listed on this divorce decree that has been filed with the court?
Yes.
And did you sign that divorce decree?
Yes, sir.
And when you signed it, did you believe that the division of assets and debts was fair and just and reasonable in this case?
Yes, sir.
And did David sign this agreed divorce as well?
Yes.
Yes.
Okay. And so, Your Honor, that's all the questions I have of Karen at this time.
All right, Mr. Howard, do you have any, I'll give you a chance to testify in a moment, but do you have any questions for your wife at this time?
No, sir.
Okay, go ahead, Mr. Ramirez.
Mr. Howard, I want to just make sure that that you heard all the questions that I asked to Karen. Did you hear all the questions and the answers?
Yes, sir, I did.
And did you work with me and with Karen to come to a resolution of your divorce as the terms are laid out in that divorce decree?
Yes, sir.
And did you sign off on that divorce decree?
I did. Yes, sir.
And do you believe at the time that you signed off on it and today that that division of assets and debts as it's laid out in that divorce decree is fair and just and reasonable?
Yes, sir.
And are you asking the court today to grant the divorce as well?
Yes, sir.
Your Honor, that's all the questions I have of either witness.
All right, and Mr. Howard, do you understand that Mr. Ramirez has worked with you and talked with you and negotiated with you perhaps to get the divorce decree agreed to, but that he was only representing your wife and he was not your attorney in this matter?
Yes, Your Honor.
All right, anything else from either side?
Not from my end, sir.
All right, Mr. Howard, anything else?
No, Your Honor.
Okay, I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. The respondent has appeared in open court and signed off on the divorce decree, indicating that he agrees to it. The petitioner had been a resident of Frio County for 90 days and Texas for 6 months before the lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were no children born or adopted during the marriage, and none are expected. And I will find that the proposed division of the marital property and debts is just, fair, and equitable. And I will approve it. And I will pronounce the divorce in open court. Any relief that does not appear in the divorce decree is denied. So this is a final appealable order.
Perfect, Your Honor. And I assume the court is going to sign it on the e-file system and I'll get my notification through the system.
I just did.
Thank you, sir. May we be excused?
Yes. All right. And Mr. Cluck, I went and downloaded another copy of the docket and I found the second page. RAM General Contracting versus Tiffany Menard. I do not see Miss Menard here.
Judge, Miss Menard has retained counsel, Kathleen Lockhart. I think you'll see her on your screen.
I'm here, Your Honor.
Okay, there we are. Okay. All right. And what do we need to hear this morning?
Judge, nothing. I'm going to work with Miss Lockhart. Miss Lockhart's going to work with me. We're going to try to refer this to mediation and hopefully resolve this matter in mediation. Did I say that correctly, Miss Lockhart?
That's correct.
Okay. All right. I wish you good luck with that. I will mark Miss Lockhart down as the attorney. And I will mark it reset on request. You're excused.
Thank you, Your Honor.
Judge.
Okay, Mr. Gerardo Trevino. You would unmute?
Yes, Your Honor.
All right. I noticed that the divorce decree has not been signed by your wife.
She hasn't signed it?
Well, here's the thing. I'm going to open up the district clerk's records right now, but either she has to sign it or she has to appear, or you have to show me proof that you have notified her of the trial today. One, that she's been served or waived appearance so that she's in the case, and two, she wants to have any say in the divorce. So let me go and pull this up. Did you have her served? Did she sign a waiver of citation or something?
I believe she signed a waiver. She didn't want to attend.
All right, let me go on. I'm trying to get onto the district clerk in Frio County. There are different sorts of waivers that people can sign. So let me see if there is a waiver, and if so, what sort it is. All right, and I see your wife filed an answer in the case. All right, sir. Your wife did file an answer. She also filed a waiver of citation, but the waiver of citation was a waiver of citation only. There's two different ways of you can waive citation. One, you say that you waive citation, meaning you waive having the sheriff serve a copy of the documents on you, and you waive everything else, that you don't want to hear anything more about it, that the judge can do whatever the judge wants to do, sign what the judge wants to sign, and you don't want to know about it. What she signed was a waiver that says all she was waiving was the right to have the sheriff give her a copy of the papers, but that was not giving up her right to be notified of court appearances. So you're going to have to either get her to sign off on it or have her present or send her notice. The best way is to the address she put in her answer, certified mail return receipt requested, telling her when the hearing is or when the trial is. You have to have proof of service on that. So what I want to do, I think I'll do right now, is I will just drop this case. I'll send the divorce decree back to the clerk's office, and I'll just drop it for now. And when you figure out whether you're going to either get her to sign off on something or appear voluntarily, or if you have to do something else, then I will, or the coordinator's office can set this for hearing. While I have you online, let me tell you a few things. One, law has several presumptions. One of them is that any child born during the marriage or for, I think, 270 days after the marriage is a child of the marriage. So if, since the day you've gotten married, your wife has had a child or she's expecting a child, unless the law presumes that that child is yours. And if that's not true, we need to get that, if it hasn't been resolved, say in an attorney general's case, then we need to get that resolved in the divorce and have it certified that you are not the father. And that's a bit complicated, but I'll just tell you, you need to work on that. Two, the law also presumes that every single thing a married person owns is community property. So it's not a matter of whose name is on it, not a matter of whether you and she are fighting over something. Anything that either of you own that's worth enough money that there might be a lawsuit over it one day, it needs to spell out in the divorce decree who gets it. Because if that doesn't happen, the law presumes that I forgot to divide it in the divorce decree, and that the two of you would still own it together. So you don't want to be in that situation. So I wish you good luck with this.
Thank you, Your Honor.
All right, now there is a Ashley Vasquez online. Ms. Vasquez, I'm asking you to unmute. All right, Ms. Vasquez. She went away. All right, so I take it there's no one here on matter of the marriage of Travis and Ashley Bradford? Okay, it looks like Mr. Mendiola and Mr. Ita are still conferring.
That is correct, Your Honor.
Okay. All right, let me get the documents for Peeler. All right, ladies and gentlemen, I am having some difficulty here with my computer, and y'all in front of me enough with the Peeler case. You know that I always say when that starts, it continues, and I just need to go ahead and reboot it. So I'm going to reboot my computer. I will look at the documents that I've been sent. Do we want to call this 10:30?
That's fine with KMG, Your Honor.
Okay, all right, I will be back by 10:30. I'm not the host, so I don't have to, you don't have to leave the meeting or anything. And I'm gonna, it's just barely working. I'm gonna try to download the things in the Dropbox. Okay, I did get in touch with that. All right, I'm gonna go ahead and leave the meeting. Maybe that'll help free up some computing power.
It's Ashley Glasses. I don't know if y'all can hear me, but I'm having difficulties too with this.
Your phone not charged?
Said no.
I don't get it. Hmm. Oh, man. I don't know if I'm doing this right. I don't know what to do. Why'd you put it so up top? No.
Hi, this is Frio.
Hello?
I just wanted to tell you, the judge gave us all a break till 10:30.
Okay.
And yeah, it's just a short break.
Okay. Yeah, Jay just told me to try to get on anyway. So you want me to check back in at 10:30?
No. I'm just another lawyer. Do what you think is best, but I wanted you to know that that's what's going on.
Okay. Okay. So 10:30.
I'm just turning my camera off and waiting until 10:30. You can do
Got
it.
it. Okay.
She's a judge. It's like, man, I don't want to dig through these papers looking for shit.
Ms. Trevino,
Yes.
this is Norma with the court coordinator's office. If you'll go ahead and mute yourself, because we can hear everything y'all are saying.
Okay.
Okay, and then just
Yes.
make sure that you're back on at 10:30.
All right.
Thank you.
Uh-huh.
All right, Mr. Ita, Mr. Mendiola, is he here?
I'm here. This is Mr.
Here you are.
Mendiola, Your Honor.
All right, I see you.
Yes, sir.
Okay, I'm back on. I was checking to see if you came to an agreement or if we need to have a brief hearing.
We are gonna try to push this through to Wednesday or whatever day the 9th is. And we're just actually gonna work today, try to have an agreement for you to sign that day.
Okay, so just reset this for the 9th?
Yes. Yeah, it's already set. It's already set. This was on.
Oh, you're gonna try and get it, all right, so just,
resolve it, button it up on the 9th.
Yes, sir, but not for a summary judgment. Looks like me and Mr.
There's no summary judgment.
Yeah, me and Mr. Hitta looks like we're doing real good in a positive direction, Your Honor.
Okay, so this is set for the merits?
Right. Yes, sir.
Okay. All right, so,
but like I said, we're
and
gonna,
Mr. Mendiola, just so we're on the same page, that means that you're either going to settle it or you're going to try it next week. Is that correct?
No, I put in a motion for a jury trial and I paid it for, it's been quite some time. I'd like to, if we're gonna do that, I would like to have a jury here, but I think we can resolve it. It sounds like we're going forward in a positive direction. I don't think, by then we should have a resolution. Sounds like, things are going good, Your Honor. But yeah, I wouldn't want to have a non-jury trial if that's the case.
All right, so do the two of you have an agreement or not? Yeah. Sounds like the answer is not. You have an agreement that you hope to agree, but you don't have an agreement on what will happen if it does agree, if you don't agree.
I mean, that's the issue. If we don't agree, then on the 9th, then we'll have to hear his. Can at that time you rule on the motion to continue or not?
Yes, Mr. Mendiola, we will hear you'll either have it settled on Wednesday or we will hear your motion for a continuance.
Yes, sir. I'm trying my best to get it settled, Your Honor, to clear this off the docket, Your Honor, and move
All right,
forward.
but I can't tell you for sure, but that's I don't know what's going to happen on your continuance. So you need to be ready to proceed if you don't get it settled.
So would a jury trial be possible then?
Mr. Mendiola, I can't give you legal advice. There can be timelines for when you have to make a jury demand. There can be reasons why you can waive your right to a jury demand. And I can't give you advice on what those are. So I just want to let you know that I'll hear any continuance that's on file for next week. But I'm not telling you that it won't go to trial. I'll have to wait and see what the arguments are and what motions I have in front of me next week.
Okay, but I did pay the jury fee and it's been like 30 days.
All right, sir. Again, I'm not going to give you an advisory opinion, especially without having had an opportunity to look at all the documents.
Okay, thank you, Your Honor.
You're welcome.
Fairly confident that we're going to have something for you to sign in the form of an agreement on the 9th.
All right, so I will mute both of y'all and you are excused.
Thank you.
All right,
Judge,
yes.
I think everything for Wilson County has been done. May I be excused as well?
Yes, ma'am.
Thank you.
I think Frio is finished also, if y'all want to take off. Or actually here, there's still Ashley floating around. Ashley Vasquez. I'm asking you to unmute your phone. Asking you to start your video. Okay. And Gerardo Trevino is coming back. Let me see what he wants. All right, Mr. Trevino.
Yes, Your Honor.
Okay, you see you signed back in?
Yes, Your Honor.
Okay, what's going on?
I got a hold of my wife so we could go ahead and try and finish this today.
Okay, all right. And you are Olivia Kathleen Trevino?
Yes, sir.
Right. All right, ma'am, have you had a chance to look at the proposed divorce decree that Mr. Trevino prepared?
Yes, sir.
Okay. And are you in agreement with it?
Yes, sir.
Okay. All right, let me ask each of you to raise your right hands. Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, Your Honor.
Okay. All right, Mr. Trevino, were you a resident of Frio County for 90 days and Texas for 6 months before this lawsuit was filed?
Yes, Your Honor.
And you're married to Olivia Trevino?
Yes, Your Honor.
And has the marriage between the two of you become undermined due to a conflict of personalities, meaning the two of you are not getting along?
Yes, Your Honor.
Okay, is there any likelihood the two of you are going to reconcile and live together as husband and wife again?
No, Your Honor.
Have there been any children born during your marriage?
No, Your Honor.
Okay. And I asked you or talked to you earlier about community property. Is there any automobile, truck, cow, horse, tractor, real estate that either of you own that's not listed in your divorce decree?
No, Your Honor.
Do either of you have any retirement other than Social Security?
No, Your Honor.
And do you believe that the division of your property and debts that you've put in your divorce decree is fair?
Yes, Your Honor.
All right. All right. Mr. Trevino, do you have any questions for your husband at this time?
No, sir.
And you heard what he testified to. Is everything he said true and correct?
Yes, Your Honor.
Are you expecting a child at this time?
No, Your Honor.
And have the two of you adopted any children?
No, Your Honor.
Okay. And I explained to your husband that the law presumes that everything a married person owns is community property. So anything that's valuable enough, there might be a lawsuit over it in the future. Regardless of whose name is on it or when you obtained it, we need to spell out in the divorce decree either that it is community property and who gets it, or that it's not community property. Because if that doesn't happen, then the law presumes that you still own it together, even though you're divorced. So is there anything that needs to be put down in the divorce decree to make sure you have clear title to it or he has clear title to it?
No, Your Honor.
Your Honor.
And are you asking to have a previous name restored?
Yes, sir.
What is that?
Olivia Kathleen Hawkins.
Hawkins, okay. And do I have your permission to type your name on the signature block and put with permission
Yes, sir.
whenever I get the divorce decree? Okay. All right. Now, Mr. Trevino, there is another document that has to be filed with the clerk's office. It's called a BV.
I'm sorry, Your Honor. You kind of broke up there.
Okay.
Could you repeat that? I'm sorry.
Yes. It's called a BVS, or Bureau of Vital Statistics sheet. Have you prepared one of those and given it to the clerk?
I don't believe so, Your Honor.
All right, then you need to get with the clerk's office. I'm asking them to unmute and get a blank BVS and get that filled out. And is the clerk's office online?
Yes, Your Honor.
Oh, okay. I was asking another one to unmute. You're up here twice. Okay. I have already returned the divorce decree in this case to you in the judge's queue. If you would send it back to the coordinator, I will sign it whenever it returns to me.
Yes, Your
Yes, Your Honor, I will.
All right. I wish you all good luck. Mr. Trevino, Ms. Hawkins, you're excused.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Last chance before we start the long hearings. Ashley Vasquez.
Yes, sir, I'm here.
Okay. Why are you here? Okay. Her audio connection is gone. I don't know if it's going to come back or not. So on the Peeler case, are we ready?
Counsel for Peelers is ready, Your Honor.
For KMG's ready, Your Honor.
Okay, and does it matter which motion we start with?
No, Your Honor.
Okay. All right. I have 1A up here as the Peeler motion to exclude and strike Mark Hemingway. And who's going to respond on that, Mr. Henry?
Your Honor, Louis Sutherland for San Miguel will respond on behalf of San Miguel.
Okay.
Honor, Mark Guthrie will respond on behalf of the Kiewit Mining Group.
And Judge Steck does not anticipate arguing today.
All right, and looks like Ashley Vasquez has left and come back. Maybe this connection will work. All right, Ashley Vasquez. Asking you to unmute your phone or whatever electronic device you're on. One more time, please unmute your phone, okay? All right. Okay. All right, go ahead, Ms. Whittle.
Yes, Your Honor. Good morning. Mark Hemingway is a principal consultant and geoscientist with GSI Environmental, Inc., with a Master of Sciences degree in geology from New Mexico Tech. San Miguel has designated Mr. Hemingway to respond to multiple peeler experts despite his lack of training or qualifications in their respective fields. San Miguel has also designated him to render opinions about compliance with the federal coal ash rule, but he is unqualified to do so in no small part because EPA requires that compliance with the rule be attested to by a licensed professional engineer in the state where the facility is located, which he is not. He has never testified as to such compliance before, nor could he because he lacks the special training and licensing requirements necessary to do so that are explicitly set out in the rule. In addition, his opinions are based on an unreliable premise, his own subjective definition of permanent as opposed to the definition under Texas law set by the Texas Supreme Court. Finally, his opinions about San Miguel's future expected compliance with regulatory requirements are based on speculation and have no foundation. As a result, Mr. Hemingway's expert opinion testimony should be excluded. So returning back to our first argument, while Mr. Hemingway is experienced as a geologist and a general environmental scientist, he is not qualified to provide rebuttal opinion testimony regarding Dr. Lauren Ross's statistical analysis to set baseline background standards, Gordon Johnson's geotechnical opinions, remedy design, and opinions on whether San Miguel's operations depart from industry practice, Paul Bowman's analysis of the geophysical investigations, or Mary Sitton's opinions regarding geospatial and aerial photo analysis. Mr. Hemingway is not a professional engineer. He has no special training or expertise in statistical analysis to characterize the extent of waste contamination, geotechnical engineering or remedial design, geophysical surveys, or geospatial and aerial photo analysis, which are the specialized areas of technical expertise he purports to rebut for peeler experts Dr. Lauren Ross, Gordon Johnson, Paul Bowman, and Mary Sitton. So we are asking the court to preclude Mr. Hemingway from offering opinion testimony outside his areas of expertise. Peeler designated expert Dr. Lauren Ross is an environmental engineer. She has been a registered professional engineer in the state of Texas since 1984. Her doctoral dissertation concerned multivariate statistical analysis of environmental monitoring data. She has taught courses at the University of Texas and both the Texas Commission on Environmental Quality and the Louisiana Department of Environmental Quality regarding the use of statistics in environmental investigations, and is a recognized expert in the field. She developed the sampling programs to collect and analyze surface water and soil samples from the Pila Ranch, and to characterize naturally occurring unaffected chemical concentrations on and surrounding the Pila Ranch, and performed a detailed statistical analysis of background soil and groundwater samples at the Pila Ranch. To rebut her opinions, Mr. Hemingway did not perform any mathematical analysis, nor does he have the training or qualifications to replicate her work. When asked if he'd even done a statistical analysis, he testified, "No, we simply looked at which ones were higher and which ones were lower." His own determination of background groundwater concentrations involved no mathematical analysis or statistics. He simply compared boron concentrations in groundwater wells and assigned as the background value the amount of boron present in the wells that appeared in his estimation to be down gradient of the sources. In other words, he assumed that anything up gradient of the sources was background. By relying on that intra-well comparison, he ignored the possibility that his estimation of groundwater flow down gradient of the sources might be wrong, even though the plant has been operating for over 40 years and may have polluted groundwater in all directions in that time. The fact that he didn't even consider the possibility that all the groundwater under a 40-year-old coal plant with admittedly leaking ponds is contaminated renders his opinions unreliable. He certainly never attempted to rule it out. He admitted that he didn't even consider it. Peeler designated expert Gordon Johnson is expected to testify about remedial options to address the soil contamination, vegetation loss, the coal ash waste impoundments, and the former coal mine on the Peeler Ranch. He is also expected to testify about management practices at the plant and the mine that resulted in contamination to the ranch, and how these practices departed from industry and regulatory standards to the extent those claims are still live. Mr. Johnson is a professional engineer and received a Master's of Science in Civil Engineering, specializing in geotechnical engineering from the University of California at Berkeley in 1984. Again, Mr. Hemingway is not a professional engineer, nor a civil engineer, nor does he have training in geotechnical engineering or mine reclamation. He is not qualified to rebut the opinions of Gordon Johnson regarding geotechnical engineering, remedial design, or San Miguel's operational practices at the plant and the mine, and whether they comport with industry practice and should not be allowed to do so. Peeler designated expert Paul Bowman is a professional engineer and a professional geophysicist. He received a master's degree from the University of Waterloo in hydrogeology and geophysics and has more than 30 years of experience in near-surface geophysical exploration. Mr. Hemingway, on the other hand, testified with respect to geophysical investigations that he has a basic understanding of the process and nature of the data that's generated. When asked how many geophysical investigations he has performed, Mr. Hemingway testified that in the past 20 years, he has commissioned someone else on a project he was managing to perform a geophysical investigation probably 6 to 8 times. He's not qualified to rebut Paul Bowman's opinions, nor does he need to be. San Miguel already has designated Dr. Peter Peme to testify regarding the geophysical evaluations. So Mr. Hemingway should not be allowed to testify outside his area of expertise. Now, as the court heard on Tuesday, Peeler designated expert Mary Sitton is expected to testify regarding the historical development of the mine and power plant based on available records on mine and power plant operations, historical aerial photographs, and geospatial data analysis. Ms. Sitton specializes in historical aerial analysis to support remedial investigations of hazardous waste sites. Mr. Hemingway purports to base his opinions on a review of current and historical aerial photographs, but he admitted he did not use the specialized equipment that Ms. Sitton employs in developing her opinions, including a stereoscope, which allows her to see in 3D. Your Honor, using the stereoscope, Ms. Sitton can see people walking around and identify the objects they are holding. That isn't something one can do with the naked eye or by zooming in, as Kiewit Counsel suggested on Tuesday. So Mr. Hemingway is not qualified to rebut Ms. Sitton's testimony either. In their response, the coal companies admit that Mr. Hemingway himself does not possess the necessary qualifications in many of the relevant fields, but they attempt to qualify him by borrowing the credentials of specialists he has worked with or supervised in the past. But Texas law does not allow an expert to serve merely as a mouthpiece for another's analysis. And one doesn't become an expert by doing something a couple of times 30 years ago in college or supervising someone else who has the technical expertise you lack. Because Mr. Hemingway personally does not possess specialized knowledge, he is not qualified to offer expert opinions on these issues. Under Texas law, Mr. Hemingway is not qualified to testify regarding areas outside his own individual expertise and cannot offer opinions regarding the Peeler expert's statistical analysis of background soil and groundwater samples, geotechnical opinions, remedy design, mine and power plant industry practice, geophysical and investigations, or geospatial and aerial photo analysis. Returning to our second argument, Mr. Hemingway is also not qualified to offer opinions regarding compliance with the federal coal ash disposal rule. Prior to this case, Mr. Hemingway has never worked at a site involving allegations of coal ash pollution or pollution emanating from a power plant. And this is the first time he has participated in a site investigation or corrective action under the federal coal ash rule. He's never offered an opinion about compliance with the federal coal ash rule prior to this case and is not qualified to do so here or anywhere. And more importantly, Mr. Hemingway has no special expertise in assessing whether San Miguel will comply with regulatory requirements in the future. Instead, Mr. Hemingway plans to testify from the mouth of a so-called expert, hearsay from San Miguel about its supposed intent in the future to comply with the coal ash rule. He testified in his deposition that the basis for his opinion was, quote, "Everything I have heard so far from San Miguel and my conversations with them makes it clear to me that they are cognizant of the requirements imposed by the rules and are trying to meet them." San Miguel can testify to its own plans for future compliance with regulations. Mr. Hemingway's opinions that he believes San Miguel will implement these future plans does nothing to aid the jury in making any factual determination. Under the Texas Rules of Evidence, his testimony is inadmissible. Now, San Miguel argues that Mr. Hemingway can testify as an expert on the coal ash rule because it is new, having been issued in 2015. But even if it were true that it is unreasonable or impossible for Mr. Hemingway to possess the necessary experience regarding the coal ash rule's application, the Texas rules do not allow San Miguel to present Mr. Hemingway to the jury as an expert when this dispute is his very first venture into the field. I wrote all the briefing on behalf of the environmental petitioners in the DC Circuit challenge to the federal coal ash rule and can still quote from the technical documents, but I am not an expert in whether something complies with the coal ash rule, and neither is Mr. Hemingway. Mr. Hemingway is certainly not an expert in regulatory compliance, and he has not disclosed any credentials, analysis, or methodologies which would entitle him to justify giving an opinion to the jury that San Miguel's actions, of which he has no personal knowledge and has not overseen, comply with the federal coal ash rule. More importantly, by the clear and explicit terms of the coal ash rule, Mr. Hemingway is not qualified to testify as to compliance with the regulatory requirements. The coal ash rule was issued under Subtitle D of the Resource Conservation and Recovery Act, and it is self-implementing, meaning there's no regulatory oversight.
Wait. I'm sorry, you broke up just for a minute. Ms. Cavazos, did you get that? Okay, you were breaking up for a moment. Go ahead, ma'am.
Yes, Your Honor. The coal ash rule.
Hold on just a minute. I've got a. Okay, I'm back. Go ahead.
Yes, Your Honor. The coal ash rule is self-implementing, meaning there's no regulatory oversight, which means that EPA had to establish rules that would achieve the regulatory standard of no reasonable probability of adverse effects on health and the environment in the absence of guaranteed regulatory oversight. And that is why EPA requires that the coal ash rule technical demonstrations be certified by a qualified professional engineer. And EPA was clear that those certifications must be made by a professional engineer licensed in the state where the facility is located. EPA was equally clear that a professional geologist, which is what Mr. Hemingway is, cannot make those certifications. And I'll share with you, Your Honor, the preamble to the rule. Here, Your Honor, EPA defines qualified professional engineer as the engineer has to be qualified to perform the task based on training and experience. And number two, she or he must be a professional engineer licensed to practice engineering under the title professional engineer, which requires following a code of ethics with the potential of losing his or her license for negligence. The agency, here, Your Honor, the agency is also requiring that the qualified professional engineer be licensed in the state in which the coal ash unit is located. And then here at the bottom of the page, Your Honor, the agency declines to allow professional geologists or geoscientists to be added to the list of professionals that can certify. And they do that because EPA is not convinced that hydrologists or geologists licensed by a state are held to the same standards as a professional engineer licensed by a state licensing board. So at a minimum, it would be contrary to the federal coal ash rule requirements to allow Mr. Hemingway to attest to San Miguel's compliance with the rule. He is not a licensed professional engineer in the state of Texas. In fact, the only expert designated in this case who is qualified to certify compliance with the coal ash rule is Dr. Lauren Ross, who is a peeler expert. San Miguel has designated no licensed professional engineer in the state of Texas to testify as to compliance with the rule, and so should not be allowed to have any expert present testimony on that issue because it would be in violation of the coal ash rule. Turning to our third argument, Mr. Hemingway also has no basis for opinions that the impacts to the Peeler Ranch are, quote, not permanent. Mr. Hemingway's opinions 3, 6, and 7 opine on whether the impacts to the Peeler Ranch from the coal company's operations are permanent, represent permanent damage to the Peeler Ranch, or represent a permanent impairment of beneficial use of the Peeler Ranch. Now, the only possible relevance of these opinions is number one, in determining whether the alleged trespass onto the Peeler Ranch was temporary or permanent, as that is defined by the Texas Supreme Court in Wheeler versus Enbridge at 449 Southwest 3rd 474. Or number two, in construing Article 8 of the buffer zone lease, which provides, in the event that there is any permanent damage to the leased premises by virtue of any spills or any other contamination originating from the operations conducted by lessees on the plant site or other operations in connection therewith, the lessors herein shall be compensated by the lessees for the reasonable market value of the land which is permanently damaged. Mr. Hemingway has no unique expertise or training to opine on what qualifies as permanent trespass under Texas law, or the legal meaning of the term permanent damage as it is used in the buffer zone lease. As this court is aware, contracts are construed as a matter of law, and an expert opinion on contract meaning is neither relevant nor helpful to the jury. Further, his opinion is based on an unreliable premise because he uses his own subjective definition of permanent, which is not a term of art in his field, instead of the legal term applied by Texas courts. In fact, when I asked him to respond to the specific questions set out by the Texas Supreme Court in Wheeler v. Enbridge Pipelines to distinguish between a permanent or temporary harm to real property, He tried to avoid answering them, deeming them unreasonable questions, and appeared confused about what I was asking. Texas law defines permanent trespass as a trespass that results in damage that cannot be repaired, fixed, or restored. Or even though injury can be repaired, fixed, or restored, it is substantially certain that the injury will repeatedly, continually, and regularly occur, such that future injury can reasonably be evaluated. A temporary trespass, on the other hand, is one that can be repaired, fixed, or restored, and any anticipated recurrence would be only occasional, irregular, intermittent, and not reasonably predictable, such that future injury could not be estimated with reasonable certainty. The proper measure of damages for injury to real property for a permanent trespass include the loss in fair market value, while the proper measure of damages for injury to real property for a temporary trespass includes the cost to restore or replace, plus the loss of use and any diminution in value based on a comparison of the original value of the property and the value after repairs are made. So while expert testimony may be admitted regarding the unimpaired market value, the impaired market value, or the reduction in market value after repairs, whether a trespass is temporary or permanent is a question of law for the court after a determination of the relevant factors. Mr. Hemingway did not even apply the relevant legal definition to his evaluation of whether harm to the Pila Ranch caused by the plant and mine operations is permanent. Instead, he applied his own subjective definition. When I asked him how he defined permanent, he said, quote, "They're not permanent in nature, and I believe they will be addressed and closed out appropriately." When I asked him to elaborate, he said, quote, "Well, that you can't make it go away. At least there's no reasonable or practical way to make it go away." That's not the definition in Wheeler versus Enbridge Pipelines. While he claimed to have approached the issue from a technical perspective, there's no generally accepted view of what qualifies as permanent damage in the field of geology, which is his area of training. And he pointed to no treatise or scientific body of thought supporting his opinions, nor did he do anything to test his opinion. Because he's attempting to provide expert testimony on legal issues and is applying the wrong standard under the law, his opinions on permanence of harm should be excluded. Finally, with respect to our last argument, Your Honor, there's no basis for Mr. Hemingway's speculation in his opinions 3, 4, 6, and 7 that San Miguel will take actions in the future to comply with regulatory requirements. Mr. Hemingway's opinions are based on the assumption that San Miguel will reasonably and responsibly manage their facilities in the future within the regulatory framework of the state of Texas. But this assumption ignores San Miguel's ongoing failure to control and responsibly manage contaminated water, wastewater, and coal ash, though San Miguel has known about the damage to the Pila Ranch that San Miguel's operations were causing throughout its operating tenure. Mr. Hemingway's opinion, in spite of the robust record of San Miguel's actions and inactions to date that have caused harm to the Pila Ranch, is speculative and unreliable. He has no special training or expertise in assessing whether San Miguel will comply with regulatory requirements in the future, and he shouldn't be allowed to testify as an expert regarding that future speculative compliance. So in sum, Your Honor, we ask the court to exclude or limit Mr. Hemingway's testimony such that he is not allowed to rebut Peeler experts outside his area of expertise, including Paul Bowman, Gordon Johnson, Mary Sitton, and Dr. Lauren Ross. We ask the court to exclude any testimony regarding compliance with the coal ash rule or opinions 3, 4, 6, and 7 that speculate about future regulatory compliance. And we ask the court to exclude opinions 3, 6, and 7 that opine on the permanence of the harm to the Pila Ranch, which is irrelevant to anything other than the construction of the buffer zone lease or the distinction made by the Texas Supreme Court in Wheeler versus Enbridge. Mr. Hemingway purports to offer a legal opinion, but applies the wrong standard, substituting his own subjective test for permanence in place of the controlling Wheeler versus Enbridge language. Thank you.
All right, let me just ask. I'll wait for Mr. Sutherland and the other, Mr. Guthrie. Go ahead, sir.
Okay, Louis Sutherland for San Miguel, Your Honor. First, Mr. Hemingway is a professional geologist, licensed geologist and geoscientist in a number of states, including Texas. He's a board certified environmental scientist by the American Academy of Environmental Engineers and Scientists. That's the preeminent board certification of professionals within this area. He has had a career for the last 35 years where he has focused on environmental site assessments and the remediation strategies for potential environmental contamination to soil, to groundwater, to surface water, to stream sediments. He spent his career predominantly in Texas, but he has experience throughout the United States and indeed internationally. This is exactly the area where he is providing opinions and testimony in this case, the core area of his expertise. He's also had substantial experience testifying before both state and federal courts and has been universally admitted as an expert in other trial settings. And Tony, let's pull up what the court had to say in a recent, well, not so recent, 9 years ago, a case in the Northern District of Texas. This is the EKQ Bridgeview Plaza case, Judge, in the bankruptcy court. This is a federal judge in the bankruptcy up in Dallas, an opinion from 2011. This case involved some contaminated property that was tied up in a bankruptcy. And if we could jump to PDF page 5 of that document, and zero in on that so the judge can see it, Tony. This is how the judge, the federal judge in that case, characterized Mr. Hemingway's credibility. Mr. Hemingway, frankly, testified in a far more credible, knowledgeable, and thorough manner. Mr. Hemingway appears to have a vast amount of expertise and experience with environmental testing of property and groundwater, including testing at former landfills. That's very similar. We're in the same basic area with respect to the scope of his testimony in this case, Judge. It's not an exaggeration to say that Mr. Hemingway is one of the most widely recognized and experienced environmental site assessment and remediation experts in the state of Texas. Now, a quick overview of Hemingway's opinions here. They focus on two basic things. One, the identification of the areas where there's environmental contamination. And two, what remedies are available and would be effective where there is environmental contamination to deal with those issues. He opines on those two things based upon two pieces of work that he did. The first is he is San Miguel's non-litigation regulatory expert that's working with them on compliance with the groundwater and contamination pieces of the CCR rule. And so he is testifying in this case based upon his own investigations that were done as part of that non-litigation work. And then secondarily, he's also testifying and rebutting the peeler experts with respect to their conclusions on contamination and remediation, both based on his work and also looking at the work that various peeler experts did. Now, what you've heard from Mrs. Whittle is that that the peelers are focused on 5 or 6 very specific things that they're kind of honing in on and saying, well, Mr. Hemingway is he's not an aerial photography specialist, and so he doesn't have the expertise to do this, or he's not a statistician, so he doesn't have the expertise to do this. And I'm going to get to those particular things, but before I do that, I want to just touch on some at least four sort of broad issues. The first is, what's notable about the peeler's motion is that it seeks to strike the entirety of Hemingway's opinions, and they don't talk about his core opinions at all. And so they're focusing in on these particular qualifications issues, but when it comes to his opinions about where is it where do we have contamination, what's naturally occurring versus contamination, and what the likely remedies might be, you would be hard pressed to even figure out what his opinions are with respect to those things if all you did is read their motion and read their reply. And the reason why they didn't focus on those things is because he's obviously a qualified expert. As the judge in the Northern District Bankruptcy Court said he's one of the most qualified and credible experts on these topics working in the state of Texas today. Second, if Texas law doesn't require you to be a statistician to testify about statistics, Texas law doesn't require you to be an aerial photography specialist to testify about your interpretation of aerial photographs. And when we look at the actual evidence in this case, you can see, based upon Mr. Hemingway's education, his experience, and his demonstrated expertise in the subject matter, that he is indeed an expert in these areas. He has expertise based upon decades of experience in the application of statistics to environmental site assessment. There's no evidence to the contrary. He has expertise in the review of aerial photographs at hundreds of sites as part of environmental site assessment. There's no contrary testimony. He is an expert evaluating multiple different types of data, whether it's geophysics, whether it's soil sampling, whether it's surface water sampling, whether it's groundwater sampling, in evaluating the aerial extent of contamination and distinguishing contamination from naturally occurring conditions. He is an expert in the selection, conceptual development, implementation, and operation of soil vapor, groundwater, and other types of environmental remediations. That is where he spent the core of his career over the last 35 years. And he's not relying, I mean, this suggestion that he's relying on other experts to get to opinions on those things is just wrong. That's his area of expertise. And we can go and we can look at his report. We can look at his CV. We can look at his deposition testimony. We attached an affidavit to our response in this matter, and all of that bears that out, that he has that expertise himself. Now, to qualify an expert under Texas law, that qualification can occur because of education, because of specialized knowledge, because of skill, because of experience, or any combination of those factors. That's Rule 702. And the Texas Supreme Court in Gamble v. Jack Williams Chevrolet made clear that that's a very practical standard. You look at the sum total of the experience and the education, and you determine whether or not that particular expert has the ability to talk about those matters with expertise such sufficiently that they can assist the jury in evaluating the facts in the case. And even the cases that the plaintiffs cite in their brief don't differ from that basic concept, that it's a combination of all those factors. And if you look at all those factors, Hemingway has these, we're talking about skills. They're tools in the tool belt of an environmental assessment, aerial photography assessment, statistical analysis. Hemingway has those tools in his tool belt to do the basic kind of site assessment and remedy selection that's at issue with respect to his opinions here. And then the third big sort of broad issue that I want to lead with is Hemingway was hired by San Miguel as a technical consultant to comply with the groundwater protection pieces of the coal combustion rule that you heard Mrs. Whittle talk about. San Miguel didn't entrust that important program that they've invested millions of dollars in to somebody who's unqualified. And moreover, Hemingway has taken many of the pieces of that project to completion at this point in time, and the successful completion of those project elements, and including submission of documents to the Texas TCEQ that is providing some oversight to this project, indicate success. So he's demonstrated that he's qualified. He's demonstrated that he's competent, not just by what he's done in the past, but his performance in this particular case. And then fourth, if you go back and you look at the Peeler's motion and you look at what's attached to the motion, what you'll find is that the Peelers largely didn't engage with Mr. Hemingway during his deposition regarding these areas of expertise. There's no testimony on his prior use of aerial photographs in the deposition. There's very little testimony regarding his prior use of statistics and his basis for expertise on statistics. This is a straw man, Judge. It's you know, a lot of rhetoric, but not a lot of there. And they make the argument, and Ms. Whittle just made it a few minutes ago, that Hemingway can't possibly be an expert in all of these areas. You know, no human being could do all this. But all of these things are tools that are part of the environmental site assessment toolbox. And each of them Hemingway has used throughout his 35-year career. Now, we didn't talk a lot about Hemingway's basic opinions, you know, his core opinions in this case. I think it's just to provide some framework for the discussion we're having here today. I think it's worthwhile to at least quickly go through those so that you have that framework, Judge. His first opinion is based upon his work assessing groundwater contamination around the power plant. And his opinion is essentially that there is very localized indications of contamination, primarily based upon boron, that is limited to the vicinity in the right around the plant. So that's his first opinion. His second opinion that's related to that one is that based upon his investigation, that groundwater is not causing any exposure to persons or any exposure to ecological resources. And the reason for that is that one, it's under the ground, and two, there's no reason to bring it out of the ground because it's naturally very saline. So it's just the water itself and its natural state's not usable. And then the third opinion, also related to this same shallow groundwater, is that contamination is not permanent, that is a condition that can be remedied using standard environmental remediation techniques. In this case, it's a combination of natural attenuation as well as the installation of a pumping system where we're accelerating the cleaning of the groundwater by taking the pumping out of the plume where it exists. And it's important to realize at this point in time that many of those projects are already in place. The closure of the ponds, which takes away the source of the contamination, is well underway, and the pumping system for the groundwater is in place. The fourth opinion,
just for my knowledge.
Yeah, sure.
They're pumping what? They're pumping water from subsurface water up to the surface. What are they doing?
Yeah. What they're doing is they're pumping the water from this very shallow groundwater aquifer, and it's an aquifer that is, you know, ranges from maybe 10 feet below the surface to maybe as deep as 30 or 40 feet, and it's well above the Carrizo is at 3,000 feet for purposes. That's the first real usable water out there. And so they put in a well field, they pump that water out, and then they send it over to the plant for treatment.
So it's filtered or treated somehow and then re-injected or run out on the surface? Or?
I'm not exactly positive about that,
okay.
Judge.
It doesn't really matter. I just wondered what that meant.
I think the answer is, and we can get you an answer, but I think the answer is the water is actually consumed. It's recycled and consumed within the power plant process.
They put it in their boiler.
It's back in the ponds, Your Honor.
Okay.
Yeah, but then the ponds end up going back to it's a zero discharge facility, and so they ends up going back to the power plant.
All right, thank you.
So fifth opinion that is Hemingway looked at a number of spill incidents and concluded that the San Miguel's response to those was appropriate. Sixth opinion is he looked at soil impacts around the power plant and delineated those impacts, developed a remedy for those impacts, and that remedy has largely been implemented at this point in time, and those soil impacts have been completely addressed. And then the seventh opinion goes to the mine issues, and he did some analysis of the geographic impact of the seeps in the mine areas, delineated the acreage impacted by those, and did some groundwater modeling on how those seeps would react to the dewatering of the pit. And so those are his core opinions that we really hadn't talked about yet, but that's the focus of his core opinions. He then also rebutted certain opinions by the peelers experts, primarily around the idea. The peeler experts, as you will appreciate, had a much broader idea of what the contaminated areas are. So he rebutted those. And that's where this background concentration thing comes in, and his disagreement with Dr. Ross about how background should be calculated. And then he also evaluated the geophysical data that was put together by Mr. Baumann as part of his rebuttal, because really two reasons. One, Mr. Hemingway believes that his opinion is that geophysical data is not sufficient to draw the conclusions regarding contamination that the peelers experts put on it. And secondarily, that the geophysical data, that is the electrical conductivity data, which is an indication of salt, that salt is essentially fully explained by what are natural conditions, except in a number of localized areas, which, he identifies. So, and then finally, the other rebuttal opinion, which will come up if we go through the specifics, is that he also rebuts Mr. Johnson's opinions with respect to what the appropriate remedial response ought to be for some of these environmental conditions. So with that kind of introduction, I guess at this point in time, I'd like to go through the specific things that the peelers have identified that they're complaining about. The first one is this idea that Hemingway is not qualified to opine regarding statistical procedures. Statistical evaluation, Judge, is a standard piece of environmental site assessment at virtually every site. You have to develop background. You have to evaluate data trends with distance. You have to many times look at statistical ratios in terms of determining the source of the contaminants. Statistics is a standard piece of the toolbox of people in Hemingway's business. That is, people who do environmental site assessments. Hemingway is, he's worked with these environmental statistics his entire career. He lays that out in the affidavit that we have attached to our response. It's at paragraph 6 and 7 in the affidavit. I'll just read you one sentence where he states in his affidavit, "I am experienced and competent in using such," and I'm inserting statistical because the previous sentence refers to it, but such statistical methods, and have used them routinely in my practice as an environmental professional throughout my career. That's in his affidavit. That statement as to his prior experience and expertise is unrebutted by any evidence by the peelers. Hemingway discusses the various statistical procedures that he uses in his report. It's pages 39 to 42 in his report. He also testified regarding where it came up in questions that Ms. Whittle asked him during his deposition. He responded with the testimony on what he did. She didn't ask him a lot about it, but you can go to his deposition at page 110, and at page 113, he does talk about some of those statistical procedures. Moreover, in his affidavit, he goes through the various statistical calculations that he did. He did do statistical calculations, and those are described in his affidavit. And then even more importantly, he references the EPA and the ASTM statistical methodologies that he uses. And so he's looking to these accepted, reliable methodologies, and that's the basis for his testimony. And we haven't heard anything from the peelers regarding that those particular methodologies are somehow unreliable. But they're specifically referenced by Mr. Hemingway. And, just going back to a point that I raised before, Hemingway doesn't need to have the title of a statistician to testify about standard statistical analyses, particularly when those analyses are required by regulatory agencies and are referenced in published standard environmental site assessment standards. And so the idea, this is just this expertise is a fundamental part of Hemingway's toolbox. He cited the recognized standards, and he's qualified to testify about those results. So moving on to the second thing, Peelers complain that Hemingway is not qualified to rebut Johnson's opinions. And Johnson's a geotechnical engineer. And they state that they argue that he lacks the qualifications to rebut Johnson's opinions as to geotechnical engineering and the power and lignite mine operations. Judge, this is a red herring because Hemingway's he's not giving any geotechnical engineering opinions, and he's not rendering any opinions regarding power plant or mine operations. But what's important here is that Johnson is also the Peelers expert on the identification of the areas of contamination that require remediation, and then what remedial strategies are going to be used to address those areas. Now that part of Johnson's testimony is right in Hemingway's wheelhouse, and he absolutely does rebut that. But he doesn't need to be a geotechnical engineer or a power plant expert in order to do that. And so just stepping back, the selection and implementation of soil and groundwater contamination remedies are core areas of Hemingway's expertise. We can go back and look at his CV. There are dozens of projects where that's what he's done. He's done it for 35 years. If we go back and we look at the affidavit that we attached as part of our response to this motion, Hemingway states, I have participated in the selection, conceptual development, implementation, operation of a large number of soil vapor, and groundwater remediations. That basic testimony, that issue wasn't developed in his deposition, and that testimony is unrebutted. Hemingway is not relying on someone else's expertise to render those kinds of opinions. It's his expertise, and he's rendering his opinions based upon his own expertise. Now, there was a lot of discussion about the fact that Hemingway is not an engineer. Well, many of these projects, when you get to the final design stage, they're complex projects. They cost millions of dollars. And so take, for example, we were talking about the groundwater pump and treat system just a few minutes ago. The well field design, that is where the wells are going to be, where specifically within the well field those wells are going to be located, how deep the wells are going to be, how the wells are screened, whether they're going to be screened between 20 and 24 feet or whether they're going to be screened between 22 and 26 feet. That's where the water is actually going to come in. Those are specific things that a geologist does. Those are things that Hemingway does when you get down to the very specifics. But once you get the water out of the ground, you got to pump it somewhere. Well, a mechanical engineer is going to design the pump. He's going to design the piping. He's going to pick the material of construction. Well, you got to get power to the pump. So an electrical engineer is going to design the motor control center. He's going to design the power supply. He's going to do all of those things. And then you got to operate it safely. So you're going to have instrument engineers that are going to design the alarm system. They're going to design the flow control valves. They're going to design the safety interlocks. As explained in Hemingway's affidavit, where there's a specific need for that kind of engineering, when you get into this detailed design phase, they work together as a team, but they're working together under his direction. But the important thing for purposes of this argument is that's not the nature of the opinion that Hemingway is giving here. He's giving an opinion as to he's not giving an opinion, let me just say it, getting myself stumbled up here, but he's not giving an opinion as to the design details. He's not opining on the appropriate size of the pump. Instead, he's opining on the selection, conceptual development, the project implementation, and the evaluation of the efficacy of the design alternatives to solve an environmental problem. That is, in other words, what remediation alternative best fits solving the problem at hand. And that's exactly what he does. That's what he's done for 35 years. And he doesn't need to be an engineer to do that. Indeed, Judge, the proof is in the pudding on this one, and that is the selection and implementation of the groundwater and soil remediation is a big part of what Hemingway did for the regulatory project of the groundwater assessment and remediation around the ponds. And one, San Miguel hired him to do it, and two, he did it and it was successful. So as again, the proof is in the pudding that the fact that he has actually done this at San Miguel is evidence that he's fully qualified to testify about it to a jury here in this case. Switching gears, Hemingway is, the peelers also make the argument that Hemingway is not qualified to render opinions regarding the misapplication of the geophysics data that was developed by their expert Baumann. And again, what's happening here is the peelers are imputing to Hemingway opinions that he's not giving. He's not giving an opinion that criticizes the mechanics of how the geophysics survey was done. He's giving an opinion regarding how that data has been interpreted to evaluate whether or not environmental contamination exists and what the areal extent of that contamination is. So the focus of Hemingway's work is the evaluation of the data. That's what he does. And so he doesn't need to be a geophysicist to do it. I mean, if you think about environmental data broadly, it's the groundwater sampling data, it's the soil sampling data, it's the groundwater elevations, you know, how that data relates to each other. Well, geophysics is just another piece of that. Geophysics, what you're measuring is the conductivity of the soil. It doesn't tell you whether or not there's contamination there, but it does give you an indication of whether or not there's any salinity present. And that can be relevant. That can be relevant to an environmental site investigation. But his assessment and his evaluation of the overall data set of both the sampling for chemicals and this geophysics data, that is within his core area of expertise. And, you know, just to reflect back to one of the opinions that we talked about a few minutes ago, I mean, essentially, the essence of Hemingway's opinion on this issue is that with some modest exceptions, that much of this data that indicates salinity, can be explained by just the natural saline conditions of soil that naturally exist on the Peeler Ranch and southern Atascosa County generally. And so, and you know, the other thing is that Hemingway has done exactly this at other sites. You know, you heard some discussion by Ms. Whittle about testimony where he said that he had had a contractor collect geophysics data for him at 6 to 8 other sites. And he testified, well, I didn't do the geophysics, but I got the results. Well, he got the results for the exact same reason that he got the results here. And that is to combine it together with all of the other available site data that he had to draw the data together to see if he could come up with a conceptual model of what was going on here that was consistent with all of the data. And that's what he did with the geophysics here. And his complaint to, or his criticism of the Peelers experts really goes to the issue that their data or their conclusions, when you look at all of the data, really point more towards natural conditions as opposed to contamination. And I mean, one of if you go back and you look at this testimony, and we included the deposition excerpts as part of our our response. But if you go back and you look at it, what you'll find is that his focus was on the data analysis is very clear within the deposition testimony. That's what his focus was, is let's look at the data and see how it matches up with everything else. And immediately after the discussion of 6 to 8 situations where he has used geophysics in the past, Ms. Whittle asked him, well, what do you do with that data? And then the next page, 2 pages, Mr. Hemingway goes through how you evaluate that data, what the geophysics data tells you about the potential for contamination, how that matches up with your soil sampling and sampling for actual chemical constituents, and what additional sampling you need to do. And so he has pages of substantive testimony that talk through all that stuff. Well, we're not getting a reliability challenge that was wrong. And, that's clearly within his ability to do the overall environmental site assessment that he's spent the last 35 years doing. He did one of the other criticisms that the peelers have focused on, at least in their briefing, is he did criticize Baumann for the density of the sampling that was conducted. By that, I mean, there were large gaps in areas where the survey was not conducted. And then the peelers experts, essentially, there's an engineering word for but they interpolated between those data points. So in other words, they assumed what the data was based upon what 2 far apart points were, and they made assumptions about what that data was in the gap. And Hemingway criticized that as well. But again, that is a data analysis issue. It's fundamental to environmental site assessment, regardless of what type of data you're talking about. If you got big gaps, you can't interpolate between those gaps. Switching gears now to the interpretation of aerial photography. This is another area where aerial photography is a fundamental piece of the toolbox of people who do environmental site assessment. I've been an environmental lawyer and been doing this now for close to 30 years, Judge. And I don't recall a single site where we did an environmental site assessment where we didn't look at environmental photographs. And Hemingway's experience is exactly the same. If you look at his affidavit, he states that he's looked at aerial photographs as part of his environmental site assessments at literally hundreds of sites. To say that he's not qualified to do that is frankly ridiculous. And the issue of stereo images is if they think that stereo images provide additional information that are not provided by the flat images, that's an issue for cross-examination, Judge. I mean, Hemingway does have experience working with stereo images, and his conclusion in this case was that he didn't need them because, 1, the flat images were good. He had good quality photographs. And 2, the 3D that you get from stereo images, what it really tells you is what the terrain is like, what the elevation change is like in the terrain. And Hemingway has probably spent more time, of all of the retained experts, he's probably spent more time out on this site than anybody else. And he knows the terrain pretty well, just based on his own personal experience.
And let me ask, did Mr. Hemingway have any criticisms of how the stereoscopic imaging was done or the conclusions reached?
No, I mean, there are differences in conclusion with respect to what the photographs show. But in terms of the methodology, I mean, Judge, San Miguel did not file a motion to challenge the testimony of Mary Sitton.
Okay. Yes. All right. Go ahead.
And, we disagree with her, Judge, but we're going to reserve that disagreement for cross-exam.
Okay.
All right. So next issue is the discussion about, well, Hemingway is not qualified to testify regarding the coal combustion rules or the coal ash rules. Sometimes people call them the CCR rules. I'll just repeat a point that I've made a couple of times already. Hemingway was hired by Sam McGowl to ensure compliance with those rules. They're not going to spend millions of dollars on a guy who doesn't know anything and can't do the work. And the results of that work have been successful. And coming back to a point that Ms. Whittle made, those rules are relatively new. They were passed in 2015. The compliance deadlines for those rules don't even occur until next year. So facilities like Sam McGowl are still doing the work to come into their initial compliance with the rule. The closure of the ponds, for example, doesn't need to happen until April of 2021. But it's really important when you're thinking about these EPA programs to think about where they came from. And the CCR rules, particularly as they relate to the pieces that Mr. Hemingway is testifying about, they didn't just come from nowhere. They didn't come from whole cloth. Indeed, those rules, their pedigree is from existing EPA programs for municipal solid waste, for industrial solid waste through the RECRA program, and through other similar kinds of programs where waste management was taking place on land. And that area, those rules that the CCR rules come from, that's the core area where Hemingway has been practicing for the last 35 years. And if you go back and you look at our brief, that's quite clear in the preamble to the EPA rule. You can go and look at the preamble, and we have a pinpoint site to the particular page where EPA explicitly says, we're getting these rules from these pre-existing EPA programs. And second, if you look at the primary environmental impacts that the coal combustion rules are designed to address, those are areas where Hemingway has decades of experience, and they include metals concentrations and salinity in soils and water. And that's, metals, boron, and the salinity are some of the key issues that we've spent talking about in this case. Third, the work that Hemingway specifically did related to the coal combustion rules. He didn't do the closure of the ponds. We've talked about our expert Powell addresses some of those issues. But Hemingway's work was focused on the hydrogeologic characterization, the groundwater monitoring, the groundwater chemistry, the existing groundwater uses. Again, we've noted that the shallow groundwater is not really usable. And then the potential remedies for any identified soil and groundwater remediation. Those areas, Judge, are areas where Hemingway has spent his career, whether it's in with respect to the coal combustion rules or not. Those issues, those technical issues upon which he is an expert, are the things where he spent his professional life. Now, the peelers haven't identified anything unique about the coal combustion rules, other than this argument that, he needs to be a licensed engineer. And they certainly haven't identified any errors where they've made an argument that the work that he has done is unreliable because of his alleged, no knowledge of the coal combustion rules. And so I think, Hemingway's prior experience with these other relevant programs and with the key relevant science, that is the site assessment, the groundwater management, and all those kinds of things, they make him fully qualified to talk about the coal combustion rules and the compliance with same. Now, this argument that Ms. Whittle has raised regarding whether or not Hemingway needs to be a professional engineer to say that he's an expert on coal combustion residual rule compliance. That's brand new. I didn't see that in their motion. I didn't see that in their reply. If I did, if somebody can show it to me and I missed it, and I'm going to apologize, but I don't remember that first thing I heard about that was this morning. But what I can tell the judge, and so I don't know, I mean, I'm not in a position to address the substance of that. But what I do know is that Hemingway has submitted documents under his professional seal as a geologist to the Texas Commission on Environmental Quality with respect to these remedial activities that have taken place under the coal combustion rules. There's a document that's known as an APAR that was, if I'm not mistaken, I don't have it with me at the moment, but I'm fairly certain that Mr. Hemingway stamped it.
Louis, this is Jennifer. I'll just add that this was the first time we heard it today, and I do have it. If you would like me to share my screen, we could do that, but I could assert to the court his professional seal is on the APAR.
Unless there's an objection that it's not, I don't need to see it.
No, his professional geologist seal is on it. He is not a licensed PE, and that is not on there.
All right. Thank you. Go ahead.
Switching topics, I want to talk for a minute about Hemingway's opinions regarding the permanent nature and timeline of the remediation. We had a long discussion, Ms. Whittle provided, with respect to how Texas tort law treats permanent versus temporary environmental torts. I'm not going to retread that. We don't agree with what she said, Judge. But what I will agree with is that the characterization of the alleged tortious injury, whether it's permanent or temporary, that is a contested issue by the parties. That is a legal issue. The Peeler's motion with respect to Hemingway, though, it sort of is, honestly, Judge, it's kind of schizophrenic, because if you look at their motion, the original motion, they say Hemingway is testifying about the law, as in whether something's a permanent trespass or not. And then if you look at their reply, they say Hemingway's testimony regarding permanent is irrelevant because he's not testifying about the law. Now, neither one of those things is a correct characterization of Mr. Hemingway's testimony. Mr. Hemingway's testimony, it was crystal clear in his deposition. He was asked by Ms. Whittle, so are you giving a legal opinion regarding whether a trespass condition is temporary or permanent? That was a question that was put to him. And his response was, no, ma'am, I'm offering a technical opinion about whether or not the chemical impacts that we see are permanent in character, or whether or not they can be readily addressed and corrected within the foreseeable future. That's a fact issue, Judge. Now, that fact issue is clearly relevant to the legal determination of whether or not the trespass, if indeed it exists, if the trespass is permanent or whether it's temporary. I mean, because as Ms. Whittle noted, the Supreme Court has said that a trespass, that the issue about whether or not a trespass is permanent turns on whether or not whether it results in damage that cannot be repaired, fixed, or restored. Well, that's essentially the same thing that Mr. Hemingway said. You know, can you address it in the foreseeable future? Is it something that as a practical matter can be addressed? And, you know, this is what he's done for a living. And so he's in a position to say whether or not reasonable and available remedies that are available to address environmental contamination, whether or not those remedies will work to address the situations that are at issue in this case. And that's a fact issue. And his testimony, but it's a fact issue that turns on expert testimony, because the natural, the lay juror is not going to know whether or not a groundwater pumping system is actually going to address contamination in groundwater. but they are going to have to decide whether or not that's possible or not. And the testimony of Hemingway is clearly going to help the jury make that decision. And the idea that somehow that's wrong, it seems crazy to me, because we have testimony about facts that lead to a yes or no on a legal question all the time. I mean, that's what trials are about. And so, you know, the peelers may disagree regarding whether a particular remedial strategy will be successful or how long that remedial strategy would take. But in determining whether or not that's a permanent injury or a temporary injury, I don't even see how you get there without having experts testify about, well, this strategy will work and this is how long it will take. And that's what Hemingway is doing here, Judge. And, you know, to the extent that they're disagreeing or they're saying that, well, Hemingway's just wrong, well, disagreements about the facts, as we've gone through a number of these hearings now, disagreements about the facts, that's not a basis to disqualify expert testimony. That's the reason why we have cross-examination. And then the final point that was raised by Ms. Whittle was Mr. Hemingway's opinions regarding the progress that San Miguel has made in accomplishing the environmental site assessment and remediation objectives, and her argument that that testimony was speculative. Again, you know, how these projects go and what can reasonably be expected in terms of the project schedule and the performance of the environmental remedial strategy, that's what Mr. Hemingway's been doing for 35 years. And I would note that, you know, many of the things that he gave that sort of testimony to have either already happened or are well underway. And just an example of the list, the implementation of the groundwater recovery well system, source control, and monitor natural attenuation is essentially done. It wasn't done when he issued his report in February. It's done now. The remediation of salt damaged soils north of the power plant, that's essentially done. The construction of an interceptor trench to contain any potential seepage of water from the equalization pond, that's part of making certain that that soil remedy stays in place. That's underway. The retrofit of the ash ponds and the construction of a new equalization basin, another area of testimony in this regard, that's well underway. The ash ponds are essentially done, and they're working on getting them finally fitted out so that they can put them into service. So, you know, I think, again, this is another situation where the proof is in the pudding that the actual events have overtaken this complaint. And, you know, Mr. Hemingway's testimony is borne out by the fact that these things are being accomplished. So, in summary, Judge, San Miguel asks that the court deny the peeler's motion to exclude Mark Hemingway's testimony in its entirety.
Okay. And was that Mr. Guthrie was going to speak?
Yes, Your Honor. Mark Guthrie, Kiewit Mining Group. Very simply, KMG adopts Mr. Sutherland's argument and doesn't really have much to add, but it disagrees with the response to the court's question about the expert sitting. KMG and not San Miguel filed a motion to exclude certain of her testimony, and that the basis for that motion, as the court heard earlier this week, was essentially non-specific opinions about contamination that are not based on state action levels. I don't think KMG has any objection to the photographs themselves, although it pointed out in its motion or its reply that if we're just talking about photographs, anybody can look at them and, you know, see that something was different. But with that exception, and that KMG does not believe that's an issue for cross-examination, that merits exclusion of her contamination opinions. That's all I have.
All right. Okay, Ms. Whittle, briefly.
Yes, Your Honor. Just two things. The fact that San Miguel hired Mr. Hemingway, who is not qualified to certify compliance with the federal coal ash rule technical specifications, because he's not a professional engineer licensed in the state of Texas, to guide their coal ash rule compliance efforts calls into question those efforts. It certainly does not convert Mr. Hemingway into a licensed professional engineer who is qualified to do that work. And the coal ash rule is very clear on this. And we stated in our motion that he is not qualified and that he's not a professional engineer. So I'm not sure why Mr. Sutherland is surprised by that argument. Also, to address the argument regarding Mr. Hemingway's opinions on permanence, Mr. Hemingway did not base his opinions on permanence using the definition in Wheeler versus Enbridge. So because he used an incorrect legal standard, his opinions on permanence should be excluded. He can testify as to the answers to those specific questions, but not render the legal opinion that the harm is permanent when he's using the wrong legal test. Thank you, Your Honor.
All right. And how long for the next motion?
Probably an hour, Your Honor.
All right, Ms. Cavazos, do you need a break before we start that? All right, we'll come back. Let's call it 10 after 12.
That's fine, Your Honor. Thank you.
Judge Wilson.
Yes.
Your Honor, we have Ashley Vasquez, who's under, well, she's under Ashley Vasquez, but it should be Ashley Bradford and Travis Bradford. Mr. Bradford was in Judge Ellison's court all day this morning. So he's going to log in into yours.
Okay. Well, I've tried to talk to Ashley Vasquez on a number of occasions and had no reply.
Yes, sir.
I'll be back at 10 after.
Okay, thank you.
I'm here, Your Honor. My phone's messing up.
Ms. Vasquez, he'll be back.
Okay, calling matter of the marriage of Travis and Ashley Bradford.
Ashley, Your Honor, I'm here.
All right, Travis Bradford.
I'm here.
Okay, let me ask each of you to start the video. And let me ask each of you to remove your hats.
Oh, sorry.
All right. Ms. Vasquez, you need to unmute too. Okay. Ashley Vasquez, are you able to unmute your phone or whatever device you were on?
Yes, sir.
Okay, where are you, ma'am?
Well, my video started first.
All right. Mr. Bradford, do you have any idea where she is physically? Or what's
Okay, there we go. I don't see anybody, but I'm connected.
I think she said she's in Kerrville.
Okay. She has been coming in and out of the meeting since 9 o'clock, and I've never been able to have a conversation with her. Sometimes I can hear her say something. Sometimes I can see the video, but nothing consistently. So let me ask you, I was given a divorce decree that has your signature, but not hers. Do you have a copy of the divorce decree with her signature?
I don't think so.
25% opportunity scholarships and military tuition discounts.
Okay.
Yeah, no, I don't.
All right, Ms. Vasquez, are you?
Today, nu.edu/Texas.
I'm sorry, sir. I'm trying to hear you. It's cutting off.
Okay, can you go somewhere where you can get a better signal?
I'm trying.
All right. Well, I'm going to go ahead and start the other hearing we have set, and I will try to come back to you later, but I can tell you that the divorce decree I have is not filled out completely. It's not close to filled out. So we're going to absolutely have to be able to communicate with both of you to get it finalized today. Otherwise, we'll not be able to get this finalized today. All right, so next we have KMG's motion to strike Lauren Ross.
Yes, Your Honor. Mark Guthrie for Kiewit Mining Group.
Okay, all right, go ahead, sir.
Thank you. I'm going to share my screen. I think. That's Can you see
Sure.
a
For
slide?
some reason, yes, for some reason they changed Zoom so that the person sharing cannot see what they're sharing.
Okay. You can see a cover slide that says KMG's motion to exclude Ross?
Yes.
All right, thank you. By way of background, Ross's role as a peeler expert, she did the sampling plan to test for background levels. She oversaw the sampling at selected locations and arranged for lab testing. She calculated background levels used in the analysis of her own and other peelers experts, except for electrical conductivity. She devised the sampling plan to prove contamination from the plant and the mine. She oversaw sampling at selected locations according to that plan and arranged for lab testing. She compared test results to calculated background levels, and she opines about contamination based on a comparison of any exceedance over background levels. To summarize our argument for excluding certain opinions of Ross, first, they're based on the incorrect standard or definition of contamination necessary to establish a tort or statutory tort claim under Texas law. And our position here parallels our position with regard to Bowman, who the court has excluded as against KMG, and our position regarding Sitten that was argued earlier this week and is pending a ruling. Her definition of contamination is based on a mere exceedance of her calculated background levels over sampling and testing of other areas instead of the state environmental action level or a protective contaminate concentration limit in accordance with environmental regulatory standards or scientifically defensible and accepted protocols. Second, her contamination opinions are unreliable because she failed to close analytical gaps on what or whose operations in the plant or mine caused purported contamination through scientific testing, investigation, or evaluation. Third, Ross offers no opinions specifically directed at KMG, and the peelers should not be allowed to offer them as such. Fourth, the opinions specific to KMG, should she offer them at trial, are not properly disclosed in designations or a report, and it would be unfairly prejudicial to hold KMG to an improper standard related to contamination and permit blanket opinions of contamination in a non-specific way. Just by way of background, mine operations started in the early 1980s. KMG was the third contract mining operator during the period of January 2011 to July 2020. KMG was not the permit holder for the mine. KMG was not the mine owner. KMG was not the plant owner. And KMG was never a party to any lease with the peelers. And based on that last point, the court granted, or in part, the court granted the motion for summary judgment based on the economic loss rule, which limits the statutory tort claims against KMG to non-leased peeler property, that is, property that is outside of the mining lease and outside of the buffer zone lease. So Ross prepared a sampling plan to show contamination from the plant and mine. And we quote here her deposition. Her sampling plan and analysis attempt to determine if sites on the peeler ranch were contaminated or had changes in chemical characteristics from the operation of the mine, the operation of the plant, or the disposal of coal combustion residuals, but not other potential sources of contamination, such as the oil and gas operations she knew that took place on the property. And as part of her sampling plan, she testified that she assumed that there was contamination from either the plant or the mine. And she applies the incorrect definition of contamination based on a low subjective standard of comparing background numbers to test results in other areas. In a report, she says, when samples from areas potentially affected by coal mining, coal combustion, coal ash, and waste disposal operations exhibit concentrations higher than natural ranges. However, the location can be presumed to be contaminated. And she further explains her methodology in her report. Whether and or where contamination from mining, combustion, or waste disposal is present on the Peeler Ranch will be determined by comparing sample measurements from potentially contaminated locations to these upper limits, which were the upper limits she calculated statistically for background. The location will be presumed contaminated. And she did not determine any level exceeding the corresponding state action level or a protective concentration limit for any contaminant. She offers no opinions specifically directed at KMG, and the peelers should not be able to offer those as such. She conceded in her deposition that she could not imagine directing any of her opinions at KMG in the lawsuit. And she testified that she did not know anything about KMG's operations or whether it actively mined on the Peeler Ranch or not. So what we're seeking is an exclusion from evidence as against KMG of any of Ross's opinions directed at KMG in the lawsuit, whether through her or through the peelers' other experts, about the fact of contamination or the causation of contamination. Now, similar to their response regarding Cnty and KMG's motion to exclude certain of Cnty's opinions, the peelers claim that the court rejected the state action level argument, and that's just false. Here are their words in their response to the Ross motion, similar again to Cnty's. Of course, this argument has been considered and rejected by the court, particularly in the context of a motion to exclude expert testimony. And then they footnote that and say that the court's instinct at the October 20 hearing was correct to the extent KMG seeks to impose a requirement that expert testimony must address exceedances to be admissible or relevant. KMG is arguing a question of law as to the elements of the peeler's claims, not whether Dr. Ross's expert opinion is admissible. Now, contrary to that, the court never rejected the argument, and we've looked at the transcripts of these hearings, that to prove a tort or statutory tort claim against KMG for contamination of their property, that the peelers must show an exceedance of the state action level. And to the contrary, the courts recognized that a different standard should apply to those claims against KMG. And we've got a copy of the transcript on this next slide, where you indicated that you would expect that there would be different standards that the peelers would have to prove to show that your client owes the peelers anything. Taco Cabana's precedent established the standard. The San Antonio Court of Appeals. You've heard about this case in a number of hearings, so I'm not going to read this one, but it's there, and you've never, as far as I know, have rejected Taco Cabana's holding. You asked if it was a question of law, whether you have to exceed some regulatory standards to get tort damages. And I believe the answer to that questions, yes. And if the court will recall, you talked about if somebody drops their glow-in-the-dark watch into a piece of machinery and it gets ground up, it could release tritium, which is radioactive. And you went on to say, there's got to be some level, it seems to me. The court has excluded Bowman based on similar arguments, solely to the extent the appealers attempt to use Bowman's testimony against KMG. As you'll recall, Bowman was the geophysical expert. Ross offers no relevant or reliant, Ross offers no relevant or reliable opinions that contamination exists on the Peeler Ranch or the non-leased Peeler property, or that KMG caused any alleged contamination of the non-leased Peeler property. She made no scientific investigation, testing, or evaluations about whether and how KMG's operations in particular caused alleged contamination. She did not exclude other sources of contamination in her determination that background exceeds other testing locations and therefore contamination. She only offers general references to coal mining, combustion, or waste disposal operations, and not any specifics about KMG. And she also didn't differentiate between KMG and the other parties to this lawsuit or the two prior mine operators with regard to her contamination opinions or conclusions. And as I indicated before, Bowman, Sitton, and Ross are sort of parallel. They each assert these contamination conclusions without offering specifics about KMG. And particularly in the case of Bowman and to a lesser extent Sitton, they're founded on other similarly unreliable opinions by the Peelers' other experts. The differences, the primary differences, Bowman used his electrical conductivity surveys, whereas Sitton looked at images, and whereas Ross used her calculated background levels in different locations compared to test results in different locations to establish exceedances, which she deems to be contamination. I'm going to skip through the slides about Taco Cabana, since we've already talked about those. The Peelers, again, have tried to cite a number of cases that don't really have anything to do with this issue. They're all distinguishable. They do concede in their response that Texas has set threshold levels for certain constituents of concern that are at issue here. And we quote the Peelers' response as to constituents for which the state has set a threshold, such as toxic heavy metals. I don't know if we need to continue on this because I think that this is already in the record and been argued too, but the TERP process has tiered processes for establishing PCLs, which stand for protective contaminant limits, or protective concentration limits, I'm sorry, for constituents of concern and Texas specific median default values under TERP. So even where there is not a state action level in a table or chart. There are processes for establishing protective concentration limits for a constituent of concern. Here's the table of some of the metals that are just default values. And just to be clear about this, Your Honor, when we talk about state action levels, we're talking about values similar to this one. And those sort of serve as a floor, if you will. And the regulatory authorities say anything below this is not an unreasonable level of contamination. So we don't even need to go further. Where something exceeds the median default values here, then you go into a risk-based analysis where you look at the exposure and what the potential harm is and where the potential harm is directed and go from there. But these are just floors. The peelers claim here that, number one, most of their complaint is about salts, and there's no state action level about salts. That's a red herring. Their expert Brown notes that threshold levels exist for salts and chlorides. Mr. Hemingway, who we just discussed, noted that one develops a protective concentration limit for chlorides in connection with salinity in soil under turf. The claims are just not about salt. The peelers refer to their contamination claims in their pleadings as a toxic brew of carcinogens, neurotoxins, and poisons, including arsenic, boron, cadmium, these other chemicals listed on the slide. But note, there's no mention of salt. And Mr. Brown's declaration that the peelers provided talks about constituents of concern. Most of these are heavy metals for which there are state action levels, but he characterizes as a surrogate for salts and chlorides, TDS, or total dissolved solids. There is a way to measure salt in an objective rather than subjective manner through TDS levels or chloride levels. There are also other regulatory schemes that are in place about salt. And one of those includes a claim that is made by the peelers in this case under Railroad Commission statewide Rule 8. And they cite a case that notes that the Railroad Commission's statewide Rule 8 provides rules and regulations to protect fresh water from pollution by salt water. And they do that based on standards rather than one number exceeding a background number. The peelers' response to the Ross motion even makes the surprising claim that the state does not care about property damage, only about damage to human health. And they do that trying to bolster their argument that state action level is not a requirement and without citing any authority. What they said was the state is not concerned with property harm. It is concerned with cancer, mortality risk, and presumes a landowner can recover under the common law harm to real property. And again, they cite no case to support that proposition. And we all know that's not true. A TCEQ manual that the peelers cite also debunks this. This manual that's entitled Conducting Ecological Risk Assessments at Remediation Sites in Texas sets out TCEQ's regulatory requirements and guidance for conducting an ecological risk assessment. Among other things, it demonstrates that the state is concerned with property harm and related ecological harm. We attached this as Exhibit E to the reply. We also attached a link to it. But it's a 300-page manual that talks about all sorts of ecological receptors, including wildlife, crops, habitats, and I won't spend the time trying to go through that, but I invite the court to take a quick look at least at the table of contents that shows the breadth of it. It also sets out a procedure to develop site-specific protective concentration limits where there is no MCL or state action level, and MCL's maximum contaminant limit. And neither Ross nor any of the peelers' other experts that opine about contamination have done this for salt or anything else for that matter. I have a if you look on the page 17, which is the PDF, if you're just looking at the document itself of the manual, it goes through the ecological risk assessment process, and there are numerous references to a procedure that is scientifically defensible for developing a protective concentration limit. The peelers also claim that following Taco Cabana's precedent would unfairly prejudice landowners. That's not true. It's already the law based on Taco Cabana, and following regulatory schemes and state action levels before you can recover tort damages for another party, from another party for contamination, provides a uniform system for everyone in Texas to be aware of and follow, instead of subjective thresholds like your tritium example, where somebody could claim that just a minor amount, which would exceed a background level, could otherwise be unreasonable contamination.
And have you found any case law, though, that deals with state action levels in Texas in a situation where the allegation is that the elements of concern trespassed across a property line, not unlike Taco Cabana, where Exxon polluted its own property and then someone else bought it, but where they just wandered across a property line and the other adjoining landowner is suing?
Yes, Your Honor, there is a case that we've cited. I'm trying to remember the name of it off the top of my head, and it might be in one of these previous slides, but I can get you that information. It's the Easy Mark case, as I recall, but I can get you that and get you the site. But yes, there is a case. The Mel Akers case at the Court of Appeals level also involved a transmission across property lines of a contaminant, and there was a discussion there. In that case, the Court of Appeals, which was trying really hard, the Houston Court of Appeals, which was trying really hard not to follow Taco Cabana, said there's only needs to be increase over a state action level at some point, and not when the lawsuit was filed, but they did recognize the state action level requirement, and it did involve a transmission over property lines by an adjoining landowner. So I think there are a couple of cases at least that that stand for that proposition.
Go ahead.
All right, the contamination opinions, again, are not specific to KMG. It's sort of like damning us with faint praise. But more like faint criticism. Ross doesn't provide specifics on KMG itself, its acts or omissions, or how any acts or omissions by KMG caused this alleged contamination. And again, doesn't address the two prior mine contract operators or any other party for that matter. Now, the peeler's response claims that KMG has challenged the method and criteria by which Ross selected and measured the baseline background areas for sampling. That is not true in respect to this motion. We have issues with that, but those issues can be dealt with in cross-examination. We also have other issues about Ross's testimony and reports that are not the subject of this motion. Number two, they say Ross was not designated to provide opinions about contamination or causation of contamination and does not offer such opinions directly against KMG. At the same time, they claim that the peelers are free to offer these opinions and other evidence for the jury's use in determining KMG's proportionate share of liability for the alleged contamination. Let's think about that for a minute. I'm sorry, didn't mean to do that. What the peelers are seeking to do here is get these general admissions or these general opinions into evidence and then argue to the jury that the jury can just sort it out and use those opinions to determine KMG's proportionate share of liability. That's essentially what they're up to, and that's not right. They also argue that exceedance of the state regulatory action level is not required to demonstrate harm to real property. We've already covered that. The peelers, based on that point 2 on the preceding slide, this is the language in their response that I'm referring to, or part of the language. Purpose of Dr. Ross's testimony is not to assign liability to any specific, but rather to provide expert testimony regarding soil, groundwater, and surface water conditions for the jury to weigh. The Cnty case that we've talked about in a number of these hearings, an expert report must provide a fair summary of the expert's opinions on the causal relationship of a breach from a standard of care to the harm claimed in the case with enough specificity to allow the trial court to conclude that the claims have merit. The peelers have not properly designated Ross to provide opinions about contamination, and their response here is a little bit misleading. They quote their timely filed third amended disclosures on page 4 of their response, and they quote what they disclosed in their third amended disclosures about Dr. Ross, which do not include any opinions about contamination or KMG's activities. You can read what it says there in red. And to characterize naturally occurring unaffected chemical concentrations on and surrounding the ranch and the results of her field investigation and sampling program and statistical analysis of background soil and groundwater samples at the Peeler Ranch. And then rebuttal. But the Peelers don't quote their fourth amended disclosures that were untimely filed 2 weeks ago on November the 18th, I believe, where they changed Ross's designation to merely state and pertinent part. Her mental impressions and opinions and summary are included in her reports, which is an improper designation, and the court should strike it because it's untimely. But the point here is that her designations don't cover contamination opinions. The Peelers, allowing the Peelers to introduce Ross's conclusions about contamination as against KMG would be unduly prejudicial. They assert broad and indiscriminate claims about contamination. Their response confirms their intent to use Ross's testimony to establish KMG's proportionate share of liability, with in addition to other evidence. But again, those opinions about contamination are based on an improper standard, and rule of evidence 403 requires exclusion or at least a limiting instruction as to KMG, as the court ordered in regard to Bowman's similar conclusions. And the unfairness is this: the Peelers would be permitted to pin these lower subjective, less stringent standards on KMG, and it would impose a higher standard of care on KMG than any imposed by Texas law. You'll recall that in these hearings, we've discussed that maybe the contract claims as against as against other parties might have a different standard for cleanup or contamination. There are no contract claims against KMG. KMG had no contract with the Peelers. So again, KMG believes that her contamination opinions that would be offered against KMG at trial of this case should be excluded as first irrelevant because they're not based on an exceedance of the state action level or a protective concentration limit or any other objective standards. They're unreliable. No specifics about KMG, again, not based on the exceedance of the state action level, and did not attempt to exclude alternative sources. The opinions specific to KMG were not properly disclosed in designations or in any of her reports, and it'd be unfairly prejudicial to hold KMG to an improper standard regarding contamination. And Your Honor, that concludes our presentation on this motion. Thank you.
Ms. Whittle? Or anything else from, it's just KMG's motion, so.
It's just KMG's.
All right, Mr. Sutherland, looks like he's gone. Go ahead, ma'am.
Yeah, Your Honor, but San Miguel doesn't have anything to add.
Yeah, I'm here though.
Okay, you're just working at your desk. Excellent.
So, Your Honor, I'd like to address two things that are just patently incorrect first. So first, on the Fourth Amendment, Fourth Amended disclosures, we did not amend Dr. Ross's disclosure in any way, except I think we said we removed something with respect to Simon Zulu because we had deposed him. But I'll share my screen so you can see, Your Honor, the Fourth Amended disclosures for Dr. Ross are precisely the same. This is the first paragraph that that Counsel for Kiewit just showed you. And then he claimed that somehow we changed this to just include this last paragraph. But our disclosure has all of this in it. It's a very detailed disclosure, including she has 5 reports that were disclosed and she was deposed. So I can't imagine what Mr. Guthrie is talking about there. And then in addition, Your Honor, I'd like to point out, Kiewit keeps arguing that somehow we didn't mention salts in our petition, but I think that's because they don't know what amounts to salts. But here in the discovery of contamination at paragraph 183, the peelers note that there's calcium, magnesium, chlorides, and sulfates. Those are all salts. And then in addition, at paragraph 188, the peelers note chlorides, fluorides, and sulfates were discovered in the wastewater discharged. Again, those are all salts. The petition talks at length about coal ash leaching into wastewater and coal ash pollution. Coal ash pollution necessarily involves salts. I mean, I can't imagine again why they think this hasn't been disclosed. We've definitely been talking about coal ash pollution, which includes salts, this entire time. So, Your Honor, the peelers have designated Dr. Lauren Ross a professional engineer who holds a doctorate in civil engineering as an expert witness to testify regarding the soils, surface water, and groundwater hydrology in the Peeler Ranch vicinity. The sampling program she developed and her characterization of naturally occurring conditions in the area and the results of her field investigation sampling program and statistical analysis of the sampling work. She's also going to testify in rebuttal to Mark Hemingway, Timothy Verslecki, and Simon Zulu. And only Kiewit has moved to exclude Dr. Ross, even though San Miguel's counsel questioned her for over 5 hours at her deposition, and counsel for Kiewit questioned her for less than 25 minutes. Dr. Ross is an environmental engineer. She's been a registered professional engineer in the state of Texas since 1984 and received a Master of Science in Civil Engineering from Colorado State University in 1982, and her doctorate in Civil Engineering from the University of Texas at Austin in 1993. As we talked about before, her dissertation concerned multivariate statistical analysis of environmental monitoring data. She teaches courses at the University of Texas and to TCEQ and the Louisiana Department of Environmental Quality regarding the use of statistics in environmental investigations. This is her specialty, and she's recognized for it, especially by the state agencies that are relevant here. She developed the sampling programs to collect and analyze surface water and soil samples from the Peeler Ranch and to characterize naturally occurring unaffected chemical concentrations, and then performed a detailed statistical analysis of background soil and groundwater sampling at the ranch. So her test was to determine, she just set out a sampling program and used a statistical analysis to determine whether something was contaminated or not contaminated with coal ash constituents. That's what she was looking at. And she designed a test that if there was an exceedance of her calculated background level, that then you would presume that it was contaminated, that area. She did not start out presuming that the property was contaminated. She established a test that if it was met, you would then presume the property was contaminated. Kiewit does not challenge Dr. Ross's qualifications as a professional civil engineer. Instead, Kiewit challenges the method and criteria by which she selected and measured the baseline background areas for sampling to be compared to the areas affected by contamination on the ranch. The thrust of Kiewit's argument is what this court has heard repeatedly from Kiewit. Kiewit complains that the peelers must demonstrate contamination exceeding a state environmental regulatory action level, which Kiewit continues to argue incorrectly is necessary for the peelers to prevail on its tort claims at trial. Next, Kiewit questions the relevance of Dr. Ross's testimony, given that her testimony isn't specific to Kiewit. Again, as with the other peeler experts, Kiewit's argument misses the mark. The purpose of Dr. Ross's testimony is not to assign liability to any specific entity, but rather to provide expert testimony regarding the soil, groundwater, and surface water conditions for the jury to weigh in conjunction with other evidence it considers to determine how to apply to each of the counter defendants. Dr. Ross does not have to do all the work for the peelers. No one expert does. And the fact that she doesn't isn't a basis for exclusion. We first have to establish that there is contamination. Then we have to establish what caused it. Then we argue about liability. And the liability in most contamination cases is based on time at the site and activities that they undertook at the site, and maybe the type of potential responsible party they are, whether you're an operator, whether you're someone who is at the site for a very short time, whether you were under instructions from someone else. Those are the types of things that would weigh into liability. Dr. Ross was first retained
all three of those items, you talked about the presence of a contaminant, whose fault it was, or who's the responsibility for it being there, and the damage that the contaminant caused. You can, I assume, prove that up with a different expert for each one of those elements.
A different expert or a different fact witness, Your Honor, because we have fact witnesses who will testify as to what they did on the site.
Go ahead. Thank you, ma'am.
So Dr. Ross was first retained in 2018, and she characterized the naturally occurring unaffected concentrations of contaminants on and around the Peeler Ranch. And then she developed her field investigation to identify and analyze water and soil samples. As she explains in her January 2020 report, as well as her supplemental report in March 2020, which were both disclosed and which she was deposed over, and again, Kiewit only deposed her for 25 minutes, she used generally accepted statistical methods to establish upper limit baseline concentration standards, which serve as conservative standards against which chemical concentrations at potentially contaminated locations can be compared. After conducting initial sampling in 2018, which was to characterize the area and establish that upper limit, Dr. Ross developed an additional sampling protocol in 2019, specifically to establish a statistically reliable baseline background sample set for soil and groundwater. The 2019 samples were collected by another party, Geostrata Environmental Consultants, from 26 soil locations and 4 background well locations. And San Miguel's consultants, I believe, were present for most of that. Based on locations chosen to represent areas of the Peeler Ranch presumed to be unaffected by either the San Miguel lignite mine or the power plant, or any associated waste or coal ash disposal. As Dr. Ross explained, the use of an upper prediction limit method to compare presumed unaffected and potentially affected areas was appropriate because a prediction limit represents the probable range of occurrence of future samples. Importantly, the test is conservative in that contamination may be present even where concentrations do not exceed that upper concentration limit standards. In her supplemental report, Dr. Ross explained that this methodology was appropriate and consistent with guidance from the US EPA for delineating waste contamination. She explained that her approach reflected an appropriate balance between the likelihood of false negatives and false positive results, or failing to identify a contaminated site as contaminated against erroneously identifying a clean site as contaminated. As she explains in detail in her supplemental report, the methodology used at the Peeler Ranch was consistent with US EPA error rate goals. Again, Kiewit does not cite to any contrary expert testimony or source material in its motion to demonstrate that Dr. Ross's approach or methodology was inappropriate or scientifically invalid, nor could it. Instead, Kiewit couches its criticism of Dr. Ross in the context of whether her definition of contamination in the design of her test, which is based on her calculation of an upper prediction limit rather than the exceedance of a regulatory state action limit. Kiewit does not, however, include any criticism that her methodology is scientifically invalid, not generally accepted, or that her methodology is unsound for any other reason. Because this court has heard these arguments repeatedly and the parties have submitted a lot of briefing on the matter, I will attempt to sum up. Number one, there are no regulatory thresholds under any applicable state program for the salts or heavy metals associated with the coal ash contamination on the Peeler Ranch. The Texas Risk Reduction Rule program requires cleanup of any bioaccumulative metal present at a site over background levels. And the TERP rule allows an operator under a cleanup order to generate a site-specific limit for salts based on ecological and aesthetic considerations. So there are no statewide regulatory thresholds for these constituents. An operator does a site-specific analysis under the watchful eye of the regulator using guidance by TCEQ. Number two, the TERP rule doesn't apply to the Peeler Ranch. The Peeler Ranch is not under any cleanup order, which is what would trigger the TERP rule. That's a critical difference between the cases on which Kiewit applies and this relies and this situation. The state in Taco Cabana and its progeny had required cleanup and then issued a no further action letter. The question in those cases was whether a subsequent landowner could bring action for negligence based on, or negligence per se, or trespass based on a theory of a duty to remove when the state had already cleared the site. And the purchaser had been aware of both the cleanup and the release. The courts in those cases found that the common law had been supplanted by the regulatory program for underground storage tanks, a program that had explicit regulatory thresholds and a program that no longer exists. Number three, the two regulatory regimes that do apply to the Peeler Ranch are the surface mining and reclamation rules and the federal coal ash rule. You may recall that defendants argued that the Railroad Commission has a pervasive regulatory regime and that it has total primacy. In fact, they've submitted a writ of mandamus to the Court of Appeals on that exact issue. I believe Mr. Holcomb even argued on Tuesday that the TCEQ rules for solid waste disposal are entirely irrelevant because the Railroad Commission controls, even though I'm certain that TCEQ would disagree with that. In any event, the Railroad Commission surface mining and reclamation rules they claim have primacy have no regulatory thresholds for any chemical constituent. And none of the rules the Peelers have alleged were violated under a negligence per se theory or the statutory cause of action have any regulatory thresholds for chemical constituents. Statewide Rule 8, for example, which Mr. Guthrie pointed out, doesn't allow the addition of any pollutant in any amount to state waters, which includes groundwater. Outside the mine area, the only regulatory regime that applies is the federal coal ash rule to the power plant surface impoundments and the landfill. The coal ash rule applies drinking water standards to groundwater, which San Miguel unquestionably and admittedly has exceeded for a number of constituents. One publication called the groundwater under the San Miguel plant the most polluted coal ash site in the country based on its exceedances of those limits. Number four, even if somehow TCEQ's TERP rule applies to the site, it would be patently unfair to require a landowner to bring its tort claims within a 2-year statute of limitations, and then also limit compensable harm to only that above a regulatory level. By the time that happens, a landowner may no longer be able to bring its claims due to limitations, which is why regulatory cleanup programs like CERCLA and RCRA and their state counterparts either specifically do not have a statute of limitations or go so far as to preempt any state statute of limitations, because it can take decades to discover that that level of harm has occurred. And it's especially nonsensical to require that any compensable harm reach a regulatory level when none even exists for the chemical constituents of concern, as is the case here. And finally, number 5, Texas law, and specifically the San Antonio Appellate Court in Terminix International versus Lucci at 670 Southwest 2nd, 657, recognize stigma damages, as does the Mel Akers Court, the appellate Houston court that Mr. Guthrie was talking about. Texas courts have established that a property owner may seek damages for the cost of repair and permanent reduction in market value after repairs are made. Stigma damages constitute monetizable damages to the reputation of the realty that continues to exist even after the property has been fully repaired or remediated. So because a property owner's ability to recover in tort for a reduction in the value of its property does not depend even on the presence of any ongoing physical harm, Kiewit cannot be correct that a landowner's tort claim is barred absent some threshold level of pollution. And as we've talked about earlier today, the Supreme Court's opinion in Wheeler v. Enbridge already limits a property owner's recovery. So the idea that they are limited in fair market value if the cost of restoration is so much higher than the diminution in value, but then they have to wait until the harm reaches a level that could be so much more costly to restore, again, puts the landowner in a terrible situation. So, Your Honor, we asked the court to reject Kiewit's request for a limiting instruction against Dr. Ross. Her testimony is relevant to provide context to the sampling that was performed and how baseline background levels were determined. This testimony is relevant to the peeler's case in chief and is not specific to any entity. Just because she does not offer testimony to create the entire link from presence and source of contamination to proportionate share of liability does not mean that her testimony isn't relevant and admissible against Kiewit. This is typical in contamination cases. No one expert can opine as to everything, especially in a case as complex as this. And the jury should be permitted to consider her testimony and opinions along with all the other admissible evidence at trial and then determine how it applies to each of the counter defendants. And just if the court is considering entering a limiting instruction, as you did with Paul Bowman, our request would be that then Kiewit can't also cross-examine that witness, which is apparently its plan, is to both get a limiting instruction and cross-examine all of our experts, and that would be patently unfair, Your Honor. Accordingly, the court should reject any argument that Dr. Ross's testimony should be specifically excluded as to Kiewit. Thank you.
All right. Mr. Guthrie, were you planning to both get a limiting instruction and cross-examine witnesses?
I guess it depends on the limiting instruction, Your Honor. If we get a ruling that it's admissible or expert testimony is admissible for no purpose against KMG, then we wouldn't really have any incentive to cross-examine. If it's a limiting instruction, like as to fact of contamination, we still might not need to cross-examine. I don't know. I don't know if I can give you a blanket answer on that. I mean, we certainly wouldn't cross-examine based on whatever the court limits, okay? But I'm trying to think how I can respond to this question better.
All right, and I'll just say, I mean, I don't know if that's a question of laws or also a question of fairness. For instance, if Mary Sitten was to be excluded as an expert based on the argument that, well, all she did was make up some maps and anybody can look at a picture and, see what she did. It's just a demonstrative. I mean, I would not allow, if she were to be excluded, I wouldn't allow the parties that had argued that she should be excluded as an expert to then go in and argue in front of the jury, well, what do we know about these maps? Where do they come from? There's no proof that they're accurate or something like that. So.
Oh, I completely
And
understand that, Your Honor. And
I think that's an important thing to consider with respect to Ms. Sitten, Your Honor, because she did have to go to various sources and find those maps. She has to be able to testify about how they are accurate and how she put them in the machines to knit them together. I mean, there's a lot of technical aspect that if they challenged, we would need someone to be able to testify about how she gathered them, how we know they're from those dates, all of that.
I think if we have an instruction that says it's not admissible as against KMG for any purpose, then we would not cross-examine. Okay.
And it's been a long time since I've taken chemistry. My recollection is that a salt is a base and an alkali and an acid chemically bound together. It's not I mean, we think of it as sodium chloride, but that salt is a much broader definition. Is that what, Ms. Whittle, the point you're making on when you're talking about chlorides and sulfates, that if they're a salt,
Yes.
that this means that they're bound together with, whether they're a base or an acid, something of the opposite charge?
Yes, and there can be surrogates like total dissolved solids used to demonstrate salt pollution, but it's not just sodium and chloride.
And do we have hearings next week?
Yes, Your Honor, including a motion for summary judgment based on the state action legislation.
Yes, Your Honor, as I mentioned on Tuesday, San Miguel is going to raise the state action levels, but in the vehicle of a summary judgment motion.
And that's was my recollection. Okay, we've had conversation about jury trials. I mean, our plan in Atascosa County has been approved, but you see whether there's valid concern or not, the level of concern is going up with the number of people testing positive. Like I said, I had a son get sent home. We all wound up keeping both kids home for a few days, and everybody in the family had to get tested. I think it's unlikely that we could take the 4 alternates, I mean, allowed by statute, and get through a 3-week jury trial. It just seems very, unlikely. It seems that there's a very, very great possibility that would blow up somehow if things are anything like what they are now, as far as the number of people who are testing positive for COVID, and if we're still excluding them all, which I think we'd have to do.
Your Honor, should we look at
Positive,
dates
but
later next year?
I would think that you'd be good to start talking about that, especially, like I said, before you start having experts carve time out of their schedule where they're going to be asking to be paid whether they're testifying or not. Now, that may not be as big an issue. Maybe that nobody's having jury trials and experts aren't in that great a demand for testimony right now.
Yes, and Your Honor, thinking through those issues, I think jury selection is going to be particularly difficult given the dealers in the community and San Miguel in the community. We're going to need a very large.
Yes, I would agree with that.
I agree.
Makes it trickier.
I would agree, yes.
I think sorry, I was just asking for jury selection. Have you considered the option of holding jury selection like in the high school stadium or some other place that's a larger area?
Oh, yes, I can, I'll post you a copy of our addendum. And it's the convention center over in Jourdanton. Over in Pleasanton is actually what we were looking at doing. Pandemic reopening.
I think if the court has dates next summer, maybe we should start looking at some of those.
Okay, I'll get with the coordinator's office about that. And I mean, we're going to have to carve out time from our schedule anyway. It would be good to be able to match up with Atascosa County, but jury week or double week if possible, but we're going to have to move the schedule around in any event. All right, so let me go to pandemic here. Jury restart, Atascosa. Okay, I just posted a copy of the addendum. I don't know if you need a copy of the actual plan. This will tell you what we're looking at doing, going over to the Civic Center in order to select a jury. But there's still a limit to how many people we could get in there.
Judge, before we dismiss today, I had one more issue as soon as we're done with this.
Your Honor, could I respond to something on the motion that we were discussing about?
Yes, let's finish that.
I need to respond to a couple of things very quickly. First of all, I need to apologize to the court about this discussion about the fourth amended disclosure. I had gotten an excerpt of the disclosure. I certainly wasn't trying to mislead because I had the entire disclosure attached as an exhibit to the reply, but somehow that excerpt was in error and just showed the last paragraph of the disclosure. So I apologize for that. And I also don't think that it really makes a lot of difference because as we looked at the third amended disclosure that was timely filed, which is similar to the fourth that's shown on the exhibit, there's still an issue with a designation about contamination opinions and KMG's activities. So that's for that. Ms. Whittle made a comment a couple of times that San Miguel questioned Ms. Ross or Dr. Ross for over 5.5 hours and I got 25 minutes. That's because that's all that San Miguel left me. And we got to the 6-hour limit and my part of that time was 25 minutes and that might have been longer than I've gotten with some of the other experts. So that certainly shouldn't be taken by the court as any I guess as anything in regard to the merits of this motion. Ms. Whittle referred to Dr. Ross's testing methodology in her testimony that her methodology was consistent with EPA guidelines. That methodology related to the statistical calculation of the background values and not the determination of contamination itself. I disagree with her statement regarding the TERP rule requiring the cleanup of any bioaccumulative metal in excess. That's not what the TERP says, but we don't have enough time to go into that. I also disagree with her arguments about the state action level analysis, but again, our motion and our reply sets forth that. She said that the statewide Rule 8 does not allow any pollution of water, the Railroad Commission rule. The rule forbids pollution, but the way pollution is determined in connection with that inquiry is not just comparing background to current condition. There's more than goes into it than that. So that's an oversimplification. The stigma damage argument's a red herring. That really has nothing to do with the merits of this and whether or not Ross applied the correct standard for deeming something contaminated. The unfairness to the landowner, we've addressed in our briefing. Bringing claims within the statute of limitations is not unfair. And as we discussed in our briefing, absent other issues, that damage has to accrue to start the clock on the statute of limitations. Damage has to accrue before the cause of action accrues. And, you know, so our arguments there don't really make a lot of sense, having to wait. Presumably, once something gets to a state action level and a damage occurs, then somebody would have the right to bring a claim within the statute period thereafter. So that argument really doesn't hold. I think that's all I have in response. So thank you.
Right.
Your Honor, just one thing, if I may.
Yes.
What Mr. Guthrie just suggested is that a landowner would need to, if they suspect there's contamination, install a bunch of groundwater wells and soil sampling and like keep testing over and over and over again until you get a violation of some unspecified regulatory threshold, and that's when your claim would accrue. But they've all filed statute of limitations claims, and I think you heard Mr. Kirstein argue a few weeks back, or maybe it was Mr. Butler, that they should have known just because they see the property, it looks like there might be a problem. They should have known and brought their claims. So I think they're talking out of both sides of their mouths on the statute of limitations issue, and that's the problem, is that they argue we are both too early and too late to bring our claims. And that's sort of been their MO for the whole case, is can we make sure the peelers have nowhere to go for relief? Not the court, not the Railroad Commission, nowhere. And this is too early, and it's also too late, and that's kind of the end of it. And that cannot be true under Texas law.
Okay, Your Honor, if I may respond briefly.
Go ahead.
We don't agree that their property's been damaged by contamination, at least by anything that KMG did. So the statute of limitations argument is based on their claim of damage and their concept of damage. And based on their claim and concept of damage, they knew or should have known, you know, more than the limitation period ago before they filed suit. But that's based on their claim of damage, and which we don't agree with. So I don't think what Ms. Whittle said is accurate in terms of speaking out of both sides of our mouths. Thank you.
Okay. All right. All right. I will see y'all next week.
Judge, this is Louis Sutherland. Can I just have 3 minutes?
Oh, yes, sir. Oh, you said, sorry, you said you had another issue. Go ahead.
Yeah. I mean, this morning we heard some argument from Ms. Whittle that I heard for the first time. We went back and checked the pleadings. It's the first reference to the fact that Mr. Hemingway needed to have certification as a professional engineer under the federal coal combustion rules to render testimony on the coal combustion rules here. And, you know, we've had just a few minutes, and I just want to show the court one document. And Jennifer, if you could just put that up. This is the state rules, Judge, on the implementation of the federal program. So you can see Chapter 352. This is the coal combustion residuals waste management rule by the state of Texas. And these are the rules where the state of Texas is implementing the federal program that Ms. Whittle was talking about this morning. And if you read down the Texas rule implementing that federal program, All engineers and geoscientific information submitted to the commission under this chapter shall be prepared by or under the supervision of a licensed professional engineer, which is what Ms. Whittle was talking about, or a licensed professional geoscientist. That's a license that Mr. Hemingway holds. He's held for a number of years. And the judgment of the state of Texas was that the licensing program under the Texas Geoscience Practice Act, which is referenced later on in this paragraph, is sufficient for professional licensing to implement the certification portions of this rule. And so this we would submit as what, if anything, we would disagree that this is a basis for excluding Mr. Hemingway's testimony, the certification requirement. But even if it is, he meets those certification requirements. That's all I had.
All right. Okay, I think I'm not the host. I will leave the meeting now and everyone is released. I'll see you next week.
Thank you, Your Honor.
Except for Lachey, we have special hearings tomorrow all day. Okay, all right. See y'all later.
Thank you, Your Honor.
Yes.
Judge, you still have the Bradford matter on there.
I'm sorry. Well, but we don't have Ashley right now.
Oh, she's still connecting.
He's gone in and out.
Judge, so you're through with Atascosa?
Yes, thank you.
Okay, thank you.
I know she's been like that for a long while now, Your Honor. I'm not sure.
Yes, I saw a picture of her in a parking lot. All right, Mr. Bradford, are you there?
Yes, sir.
All right. Have you had a chance to be in touch with your wife?
No, I don't have a way to connect with her.
Okay. All right. Well, we're not going to be able to get this done today because I don't have everything approved. Two, I know you were in Judge Ellison's court. Hopefully she heard some of this when she was online earlier. But as I said, there's a whole bunch of blanks on the proposed divorce decree, things about retirement, debts, all those different items. What I need to tell you is that the law in Texas presumes that every single thing a married person owns is community property. So it's not a matter of whose name is on a car or a house or a horse, or if you and your wife are fighting over it. If the law presumes because you're married that it's all community property, that you own all of it jointly, and if the divorce decree doesn't either say, yes, this car, truck is community property and here's who gets it, or it doesn't say, this is not community property, it's separate property and here's who it belongs to and it's not community property. If the divorce decree doesn't do one of those two things, then the law presumes that you and your ex-wife still own that property together.
We don't have any property.
Okay, well, I'm just telling you, sir, because I tell this to everybody who doesn't have an attorney who gets divorced. So you need to make sure that anything that you have would be worth a lawsuit later, wherever you got it from, whoever's name is on it, that it's spelled out who gets it. There's also dates in there that says after a particular date, each of you is supposed to pay your own debts. That was left blank. That needs to be filled out. I also need to ask you, when did you and your wife get married? And also, you don't have to take this down. When did you and your wife get married?
Probably around like 2008.
Okay. Since that day, have there been any children born to her?
Mine or
any children born to her?
I think she had 6.
Okay. Have there been attorney general cases or something, some other lawsuit that says? Okay.
Yeah, all of it has been taken care of.
All right. Well, here's the other thing I have to tell you. The law in Texas also presumes that you, the husband, are the father of any child born during the marriage. So we have to mention all 6 of those kids in the divorce decree and then make a reference to the cause number and the county and the style of wherever the case was that somebody else was adjudicated by a judge to be the father of those children. And I'm going to need a copy. It didn't have to be certified, but I need to be able to see a copy of those orders. Now, if it happened in Atascosa County or Wilson or Frio or Karnes, I can go online and I can look things up over the internet with the district clerk's office. But if those lawsuits happen somewhere else, Kerr County, for instance, I don't have access to the district clerk's office in Kerr County, and you're going to have to get copies of those documents for me.
Okay.
So what I would suggest is you may want to talk to an attorney about this, but again, we need to have it fixed on the property, on any retirement and the date that you're going to each pay your own debts from. And we need to recite who those 6 kids are and show where it was that there was a lawsuit that already judge ruled that you weren't the father. And if that hasn't happened on any of them, we need to see if you and your wife and the biological father, that there's affidavits that sometimes get signed. I need to see if that has happened. But I have to have proof that you're not the father of those children.
I have the entire court case on paper.
That's great.
So what do I do with that? Do I turn it into the district clerk so you can get it?
Well, you can make a copy of it, yes, sir, and let them
Okay.
send a copy of it in. All right. But is that did they do all 6 of them at once, or is this at different times?
Yeah, all 6 of them.
Well, you got lucky. That's easy. I was afraid that we're going to have copies of documents from 6 different places. And we also will need to know, is your wife pregnant at this time?
No, she's not.
Okay, well, and we'll ask her about that. Hopefully she'll be at the final hearing, because if you're also presumed to be the father of any child born for, I think, 270 days after the divorce. So we'll need to know if she's pregnant. The last thing I need to talk to you about is, what was it? Did she sign a waiver of citation? Did you have her served? What happened?
Yeah, I had her served.
Okay, and has she made an appearance in this case? Well, she's made an appearance now. She showed up. So if you can't get her, signature on the divorce decree, you need to get her to show up in court. And if she's not going to do that, you need to set the trial out far enough with the court coordinator that you can send a copy of the order of the setting that says when it is, the time it is, the Zoom meeting information, all that, so that you can send that to her certified mail, return receipt requested.
Okay.
All right, because if she just fails to show up, I have to know that she's failing to show up after she knew when the trial was, and that she's not there because she just blew it off, and not that she didn't know about it.
Okay.
Okay. All right. I wish you good luck, sir. And I'm going to go ahead and I'll ask Norman to leave in the meeting, and I'm going to go ahead and take off.
Okay. Thank you.
Yes, sir. Bye-bye, Ms. Jane.
Bye.
Bye, Judge. Thank you.
Yes, ma'am.